Good morning, everyone. I hereby call this meeting of the Government Administration and Elections Committee to order and simultaneously recess it, subject to the call of the chair. We anticipate reconvening at roughly 11:30 a.m. Thank you.
will be open for the Environment Committee until 2 p.m. and votes will be taken in the environment area in room 3200. The Environment Committee will hold votes open until 2 p.m. in room 3200.
Good morning. Oop. Turn the volume off on my computer. Good morning for 10 more minutes, everyone. I hereby reconvene this meeting of the Government Administration and Elections Committee. One sec. Can everyone hear us who's on Zoom?
Yes, thank you.
Thank you very much, Representative Santiago, for confirming that. So we are reconvened in this meeting to JF and JFS bills. Are there any remarks from my co-chair? Seeing none, we move to item Roman numeral number 3, which is bills and resolutions for final action in committee. And we will start with item number 1. Item number 1 is Senate Bill number 1226, an act establishing an exemption from disclosure for certain higher education records pertaining to teaching or research under the Freedom of Information Act. This is a JF to the floor. I will entertain a motion. Moved by Senator Flexer, seconded by Representative Haddad. Are there remarks? Representative Mastrofrancesco.
Thank you, Mr. Chairman. Mr. Chairman, if I recall, this is the same bill that we talked about last session, I believe. The issue that we have with this is that this is property that really belongs to the taxpayers of the state of Connecticut. And this includes any of the research that the school is doing. Our thought and my feeling really is that this should not be exempt. And people do pay the bills. They are paying for the schools to fund them. They are paying the salaries. This should be information available to the taxpayers of the state. So I will be opposing this bill today. Thanks.
Thank you, Representative Mastrofrancesco. Further comment from the committee. Senator Sampson.
Thank you, Mr. Chairman. Yeah, I don't know that I'm going to say anything particularly different than my colleague. I just wanted to remind everyone, this bill, it refers to public research that is provided at public universities. And it's a very broadly written bill. I mean, it's a simple short paragraph, if I recall. I'm actually, oh, you've got it right here. Okay. Yeah. Basically, it would protect from freedom of information records maintained or kept on file by or for the faculty or staff of a public institution of higher education arising out of teaching or research on medical, artistic, scientific, legal, or other scholarly issues. Again, and it goes on, it's a very, very broad definition. I'm not suggesting that we couldn't maybe find some small area of agreement where there are certain things that maybe viable conversation, but to me, this is all encompassing. And the fact of the matter is, if you are employed at a public research university, you've got to have an expectation that your public research belongs to the people paying for it, which is the taxpayers of the state of Connecticut. So based on that, I'll be a no as well today. Thank you.
Thank you, Senator Sampson. Further comment from the committee. Seeing none, Mr. Clerk, would you please call the roll?
This is a roll call vote for SB number 1226, an act establishing an exemption from disclosure for certain higher education records pertaining to teaching or research under the Freedom of Information Act. The motion is to JF to the floor. Senator Flexer.
Senator Flexer votes yes.
Representative Blumenthal.
Yes.
Senator Honig.
Senator Honig votes yes.
Representative Morambello.
Morambello votes yes.
Representative Osborne.
Osborne votes yes.
Senator Sampson.
Sampson's no.
Representative Mastrofrancesco.
No.
Representative Bronco. Representative Carpino. Representative Foncello.
Foncello's no.
Sorry about that. Representative Gauthier.
Representative Gauthier, yes.
Representative Haddad. Representative Hoxa.
Hoxa's no.
Representative Johnson.
Yes.
Representative Metapace,
Yes.
Representative Rosario, Representative Santiago,
Santiago, yes.
Representative Shannon,
Shannon votes yes.
Senator Winfield, thank you, Mr. Chair.
Thank you, Mr. Clerk, and the votes will be held open until a time to be announced later. We're going to take a brief pause now because we did have a remark from the chair that I forgot to mention, and so I'm going to hand it over to my co-chair, Senator Flexer.
Thank you, Mr. Chair. Forgive the deviation, but since we've last met as a committee, we have a new clerk. And so I just wanted to take a moment to acknowledge Murray Sento, our new clerk. He's been doing a great job over the last few weeks, and welcome him to our committee, which I should have done at the beginning of the meeting. So I apologize, but welcome, Murray, and thank you so much for your work thus far. And we're excited to work with you over the next several months.
I'm glad to be here. Sorry.
No, thank you. Thank you, Mr. Chair.
Thank you, Madam Chair. Next up, we have item number 2, Senate Bill number 1227, an act increasing various monetary thresholds under the state codes of ethics. This bill would increase the monetary thresholds for various prohibitions, requirements, or other additional conditions under the state codes of ethics. This is a JF to the floor, and I will entertain a motion. Moved by Senator Flexer, seconded by Representative Morinbell. Is there comment from the committee? Representative Master-Francesco.
Thank you, Mr. Chairman. Mr. Chairman, Madam Chair, this is the same bill, I believe, as we did last year. If you wouldn't mind just kind of giving us an overview on exactly what it does. I know that there's very minimal increases on these monetary thresholds, if you wouldn't mind doing that. Thank you.
Yes, thank you, Representative. So, yeah, this bill just increases some of the statutorily determined dollar amounts in the state code of ethics. We've worked closely with the Office of State Ethics like we did last year on this bill, and it just increases some of the thresholds, given that many things now cost more than they did, and some of these provisions haven't been updated in 2 or 3 decades. Thank you, Mr. Chair.
Thank you, Madam Chair.
Thank you for that answer. It's good that we were working with the ethics department. There are very minimal changes to the thresholds on this, so I will be supporting it today. Thank you.
Thank you, Representative Master-Francesco. Further comment from the committee? Seeing none, Mr. Clerk, would you please call the roll?
This is the roll call vote for SB 1227, an act increasing the various monetary thresholds under the state code of ethics. The motion is to JF to the floor. Senator Flexer,
Senator Flexer votes yes.
Representative Blumenthal,
Yes.
Senator Honig.
Senator Honig votes yes.
Sorry, do you mind please turn on your camera for the future?
Sure thing. Sorry.
Representative Osborne,
Representative Osborne votes yes.
Representative Morinbello,
Representative Morinbello votes yes.
Senator Sampson,
Sampson is yes.
Representative Master-Francesco,
Yes.
Representative Branco, Representative Carpino, Representative Fonsello,
Yes.
Representative Gauthier,
Gothier, yes.
Representative Haddad, Representative Hoxa,
Hoxa votes yes.
Representative Johnson,
Johnson is yes.
Representative Menapace,
Menapace is yes.
Representative Rosario, Representative Santiago,
Santiago, yes.
Representative Shannon,
Shannon votes yes.
Senator Winfield.
Senator Winfield, in the affirmative.
Thank you, Mr. Chair.
Thank you, Mr. Clerk. Next up, we have item number 3, Senate Bill number 1228. This is a JF to the floor. An act designating Indigenous Peoples Day as a legal holiday. The bill does exactly what it says it does. I will note, because I'm sure inquiring minds want to know, it does not specify a date. I will entertain a motion. Moved by Senator Flexer, seconded by Representative Shannon. Is there further comment from the committee? Representative Massafrancesco.
Thank you, Mr. Chairman. So it does not specify a date. Do we have any indication at all of a date or what they were thinking, or can you elaborate on that? Through.
Thank you, Representative, for the question, and thank you, Mr. Chair, for the recognition. So it doesn't specify a date, although we have heard from some tribes representing Indigenous people that they're looking at dates in November around Thanksgiving. And our hope is to get more input, as we looked for last year, from groups that represent Indigenous people from different tribes and others, in terms of what day they think is the appropriate day to recognize Indigenous people. But most of the feedback we've heard thus far are days in November.
Representative Massafrancesco.
Thank you, Mr. Chairman. Thank you for that answer. So the concern I have with this is obviously we want to celebrate Indigenous Peoples Day, which is absolutely wonderful. But I get concerned of the amount of holidays that the state workers have right now and the cost to the state and to the residents. Right now, they are awarded 15 vacation days, 15 sick days, 13 holidays, 3 personal days. It comes to about 46 days a year, which is about 9 work weeks. On top of that, we have many of our departments still working from home a percentage of the time. So for those reasons, Madam Chair, I'll be a no today. Thank you.
Thank you, Representative Massafrancesco. Further comment from the committee? Seeing none, Mr. Clerk, would you please call the roll?
This is a roll call vote for Senate Bill 1228, an act designating Indigenous Peoples Day as a legal holiday. The motion is to JF. Senator Flexer. Representative Blumenthal.
Yes.
Senator Honig.
Senator Honig is yes.
Representative Moore Bello.
Moore Bellows, yes.
Representative Osborne.
Representative Osborne's a yes.
Senator Sampson.
Sampson is no.
Representative Massafrancesco.
No.
Representative Bronco. Representative Carpino. Representative Fonsello.
No.
Representative Gauthier.
Gothier, yes.
Representative Haddad. Representative Hoxa.
Hux is no.
Representative Johnson.
Yes.
Representative Menapace.
Yes.
Representative Rosario. Representative Santiago.
Santiago, yes.
Representative Shannon.
Shannon votes yes.
Senator Winfield.
Senator Winfield, in the affirmative.
Thank you, Mr. Chair.
Thank you, Mr. Clerk. Next up, we have item number 4, Senate Bill 1229, an act concerning fees for copying, reviewing, and redacting records created by police body-worn recording equipment and dashboard cameras. This is a JF to the floor. I will entertain a motion. Moved by Senator Flexer, seconded by Representative Moore Bello. This bill would take a number of measures to, first of all, ensure that body-worn recording equipment recordings, as appropriate, are available to the public. It would generally allow public agencies to charge requesters a fee for their time spent redacting body camera or dashboard camera recordings if it takes more than 4 hours. It prohibits certain redaction fees or certain fees for certain requesters, including involved persons, so someone who's depicted, their parent or legal guardian, or an attorney representing them. It would mandate that certain records be available regardless of fee, without a fee, including police-involved shootings or motor vehicle accidents, or formal statements about the use of force and any allegations of misconduct by a police officer or the officer is subject of a disciplinary investigation. It requires agencies to waive certain redaction fees for the same reasons FOIA requires, waiving copying fees, and a number of other protections that have been negotiated. This is the same language that was the final version of this bill in the Senate, I believe, last year. It was ultimately not passed in the House. Are there further comments from the committee Senator Sampson.
Thank you very much, Mr. Chairman. This bill, again, you did a great job of explaining the bill and so forth. I don't really have anything to add. I just wanted to point out that this bill was very close to making it over the finish line at the end of last session. And I know that this has been a lot of hard work on all sides of the issue to come to a negotiation that is amenable to all the parties. And it's also got a duplicate bill that is going through the Government Oversight Committee. I don't know why we have duplicate versions, but hopefully since we've got two of them, and I presume we're going to JF this bill out of this committee too, we'll have two options to go forward. The one thing I would strongly suggest is that the bill stays as is, barring some minor tweaks here and there. I worry that any other type of things get added to it along the way. I just hope that doesn't happen because I think it will fly through otherwise. And I'll just leave it there. Thank you, Mr. Chairman.
Thank you, Senator Sampson. I would echo your comments. This has been heavily negotiated by all parties to try to make sure that we're striking the appropriate balance between the really voluminous amount of video that's being created through our body-worn and dashboard cameras and balancing the privacy concerns of those depicted in those videos and the high cost it takes to redact them on behalf of our law enforcement agencies with the public's right to know under our FOI laws. So I would echo the comments of the distinguished ranking member. Are there any further comments from the committee? Seeing none, Mr. Clerk, would you please call the roll? Sec. Yes. Apologies. I thought I missed someone on the Zoom. Seeing no further comments from the committee, Mr. Clerk, would you please call the roll?
This is a roll call vote for SB 1229, an act concerning fees for copying, reviewing, and redacting recording records created by police body-worn recording equipment and dashboard cameras. The motion is to JF to the floor. Senator Flexer,
Yes.
Representative Blumenthal,
Yes.
Senator Honig,
Senator Honig votes yes.
Representative Morin-Bello,
Morin-Bello votes yes.
Representative Osborne,
Representative Osborne votes yes.
Senator Sampson,
Sampson is yes.
Representative Master Francesco,
Yes.
Representative Bronco, Representative Carpino, Representative Fonsello,
Yes.
Representative Gauthier,
Gauthier, yes.
Representative Haddad, Representative Hoxa,
Hawk says yes.
Representative Johnson,
Yes.
Representative Menapace,
Yes.
Representative Rosario, Representative Santiago,
Santiago, yes.
Representative Shannon,
Shannon votes yes.
Senator Winfield.
Senator Winfield, in the affirmative.
Thank you, Mr. Chair. Thank you, Mr. Chair.
Thank you, Mr. Clerk. And as of now, the votes for this committee meeting will be held open until 4 p.m. All right, next up, we have item number 5 on our agenda, Senate Bill number 1230, an act concerning purchase of print and digital advertising by the state. I will entertain a motion. Oh, I'm sorry. We're going to pause for a moment because I think we have a recusal coming.
I do. You do. Thank you, Mr. Chairman. I'm not one to recuse myself or miss a vote, but on this particular one, I don't want it to be a conflict from a business that I own, which is a newspaper. So I'm going to recuse myself on this vote today. Thank you.
Thank you, Representative Master Francesco. Let the record reflect that Representative Master Francesco has recused herself from item number 5 on our agenda, and I will recall the motion. And we'll wait until she leaves the room. Moved by Senator Flexer, seconded by Representative Morambello. This is a,
Mr. Chair, my apologies. Could you just clarify what that motion is?
yes, I was about to say, this is a JFS to the floor, LCO number 5602. I have heard a motion from Senator Flexer and a second from Representative Morambello to JFS this bill to the floor with LCO number 5602. Representative Morambello, would you please introduce the bill?
Thank you, Chair. This bill is an effort to support our local media outlets at a time when a lot of them are dwindling. It will redirect a small portion, about 15% of already budgeted state government dollars for advertising to our Connecticut outlets. There are carve-outs for specific entities and allows a waiver option for others. And it excludes out-of-state tourism, economic development, or employment recruitment, and it also has a reporting component to it.
Thank you, Representative, for that thorough introduction. Senator Sampson.
Thank you very much, Mr. Chairman. As you mentioned, this is substitute language. And the one thing that obviously sticks out is the change on line 15 from 50%, which was in the underlying original bill, to a reduction to 15%, which is notable. I saw there are a few other changes in the substitute language. I'm just curious if there's anything of any real substance there, or they're just conforming through you.
It also removes.
One sec, let me just recognize you.
Sorry.
Representative Morambello.
Thank you, Chairman. It also removes Yukon from it.
Thank you, Representative Morambello. Senator Sampson.
Thank you very much, Mr. Chairman. One other question that I have has to do with the language that is, I was going to try and find it in the bill, but it says that this applies to corporations that are headquartered in Connecticut. And presumably that would preclude businesses that operate in Connecticut but may be owned by an entity from outside the state. Is that correct?
Representative Morambello.
Oh, yes. Thank you, Chair. Yes, it shall deem the location of the parent company. It'll be determined by the parent company. And I just want to clarify that it's all higher ed that's been removed, not just Yukon.
Thank you, Representative Morambello. Senator Sampson.
Thank you very much, Mr. Chairman. I appreciate that answer as well. Yeah, you know, this bill has been kicking around here for the last couple of years. I mean, I think it's actually been changed considerably to be far more reasonably drafted. The 15% number, I think, is more appropriate. For me, to me, it's just a simple question of whether or not I think it's good policy at any level, whether it's 1% or 99%, to suggest that the taxpayers of the state of Connecticut must use their funds to target an in-state business for their purchase. It sounds good. You know, we've had this kind of idea discussed many times before in various committees on various topics, whether we're talking about making other types of purchases or labor that's used from out of state and so forth. At the end of the day, you know, I don't see a really strong, compelling state interest in making sure that we use an in-state entity. The fact of the matter is the taxpayers of Connecticut are paying the bill, and if they can get the services for the most reasonable price from an out-of-state entity, then I have no objection to using them. And that's really goes to my concern over interference with the marketplace generally. I don't think that the state of Connecticut or anyone should be making policy that interferes with the natural competition that exists for things, and that includes advertising dollars. And forgive me for kind of getting in the weeds on it. I just wanted to express my objections in the most thorough way possible. I'm going to vote no on this bill. I understand the intent behind it. We're trying to preserve the makeup of the state of Connecticut's media, entities that exist, and we, and protect them to some degree. But I believe that that's a market-based consideration and not something the state should be involved in. So I'll just leave it right there. Thank you very much, Mr. Chairman.
Thank you, Senator Sampson. Further comment from the committee? Representative Hoxha.
Thank you, Representative Blumenthal. Yes, I did have just a quick question for anyone here on this committee that could potentially answer it. It was brought to my attention that particular companies, media companies that are not necessarily based in Connecticut, but own a lot of Connecticut-based newspapers, would not qualify for this, would not benefit from the proposed benefit that would be extended via this bill to Connecticut-based companies. Is that true that if the headquarters or the parent company of a particular newspaper that we know to be a Connecticut newspaper, if the parent company is based in another state, would that company and all of its subsidiaries, all its other newspapers that it owns, publications that it owns, benefit from this bill insofar as what the intent of this bill is trying to achieve? Through you, Mr. Chair.
Thank you, Representative. Representative Moran-Bell.
So are you, thank you, Mr. Chair. So are you asking that if a business is outside of has its parent company outside of the state of Connecticut, then it would not be included in that 15%? That's correct.
Representative Hoxha.
Yes, I believe that's what I was asking. Okay, so I'm probably going to vote no for this because I don't believe in the concept. I believe in competition regardless of where that comes from, unless there's a very special circumstance. But what I think the intent of this bill is, and correct me if I'm wrong, is to keep Connecticut-based publications alive by essentially diverting a certain percentage of advertising revenue directly to them. But if now a lot of those newspapers will not be getting that advertising revenue, or be selected to advertise with, depending on how you look at it, because of the fact that a parent company that owns these newspapers is not based out of Connecticut, then does it not defeat the purpose of what the intent of this bill is trying to accomplish? Through you, Mr. Chair.
Representative Moran-Bell.
Thank you, Mr. Chair. I know there's a question in there somewhere. I'm not sure what it is. I will say that the intent of the bill is to support our local news organizations by diverting some of our funding to them. I don't know if that answers your question.
Representative Hoxha.
Through you, Mr. Chair. Respectfully, it doesn't. So let me, and that's could be my fault in the way that I asked my earlier question. So let me try to simplify it. You had previously said that if the parent company of, let's just say hypothetically here, it's not important to bring up any specific names, but just hypothetical scenario. You had said that in the previous question, prior to the question that's being asked now, that if the parent company of 5 or 6 publications owned by that parent company, if that parent company is not based in Connecticut, then all those publications, even though those are based out of Connecticut and have traditionally been based out of Connecticut, would not be benefiting from this bill. So my question now is that, doesn't it seem a little, I don't understand what the purpose of this bill would be if it still is disenfranchising some Connecticut-based publications because of the status of their parent company. So am I understanding that correctly? That because of the status of the parent company, that some Connecticut publications would not would not benefit from the intent of this bill. Through you, Mr. Chair.
Representative Moore Bell.
Yes.
All right.
Okay,
Yeah.
now I'm understood, Mr. Chair. Thank you.
There further comment on this bill from the committee? Thank you, Representative Hoxa. Seeing no further comment, Mr. Clerk, would you please call the roll?
This is a roll call vote for SB 1230, an act concerning the purchase of print and digital advertising by the state. The motion is to JFS LCO number 5602 to the floor. Senator Flexer,
Yes.
Representative Blumenthal,
Yes.
Senator Honig, Representative Moore and Bello,
Yes.
Representative Osborne,
Yes.
Senator Sampson,
Sampson is no.
Representative Bronco, Representative Carpino, Representative Fonsello,
No.
Representative Gauthier,
Gauthier, yes.
Representative Haddad, Representative Hoxa,
Hawk says no.
Representative Johnson,
Johnson is yes.
Representative Menapace,
Yes.
Representative Rosario, Representative Santiago,
Santiago, yes.
Representative Shannon,
Rep. Shannon is a yes.
Senator Winfield.
Senator Winfield, in the affirmative.
Thank you, Mr. Chair.
Thank you, Mr. Clerk. Next up, we have item number 6 on our agenda, Senate Bill 1231, an act concerning state contracts with nonprofit human services providers. The chair will entertain a motion to JF this to the floor. Moved by Senator Flexer, seconded by Representative Moore and Bello. This bill would require the Secretary of the Office of Policy and Management to conduct reviews of the level of services and reporting requirements of nonprofit human services providers, and would repeal certain provisions concerning the cost allowance cap for executive director salaries and certain state agencies' calculations of grants to non-state organizations that provide employment opportunities, day services, or residential facility services. Is there comment from the committee? Senator Sampson.
Thank you very much, Mr. Chairman. Yeah, so we had some conversation about this in our caucus this morning, and also between the leadership of this committee just earlier before we started. I think that there is a desire to move this piece of legislation. Generally speaking, I think that we all recognize a need to make sure that nonprofit providers are paid on time, which is, I think, the lion's share of the bill. And I would really like to see this thing make it out of committee unanimously if possible, and hopefully make it to the finish line. We did, at least on the Republican side, have some objection to the final section of the bill, which is section 4. This is a section that would repeal the caps on the pay for CEOs for nonprofits. I fully recognize there was an issue there, and that the current statute might be limiting in the sense that various nonprofits can't find appropriate and qualified people to fill those roles based on the current statute, and certainly willing to continue a conversation to address that and come up with a solution. But I am not willing to support section 4 as it is, which would remove any cap whatsoever, and basically, you'd have the Wild West determining exactly what that CEO pay would be. So I would like to, as a result of that, offer a friendly amendment, hopefully, to remove section 4 of the bill and just move forward with the rest of it. I make that motion, and hopefully someone will second it.
Moved. The amendment to remove section 4 from the bill is moved by Senator Sampson, seconded by Senator Flexer. And I would just say that I do consider this a friendly amendment in service of the continued conversation on this bill. Again, we're going to continue to work on this bill, to negotiate on this bill. And this amendment is without prejudice to any future form of the bill, but in service of the conversation, we consider this a friendly amendment, and I would encourage all my colleagues to vote for it. If there is no objection, I would entertain a voice vote. Seeing no objection, all in favor of the amendment, say aye.
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 All opposed? The ayes have it. The amendment is adopted. Is there further comment from the committee on the bill as amended? Seeing none, Mr. Clerk, would you please call the roll on the bill as amended?
This is a roll call vote for SB 1231, an act concerning state contracts with nonprofit human service providers. The motion is to JFS to the floor with Amendment A to remove Section 4. Senator Flexer,
Yes.
Representative Blumenthal,
Yes.
Senator Honig, Representative Morin-Bello,
Yes.
Representative Osborne,
Yes.
Senator Sampson,
Sampson is yes.
Representative Master Francesco,
Yes.
Representative Bronco,
Yes.
Representative Carpino, Representative Fonsello,
Fonsello's yes.
Representative Gauthier,
Gothier, yes.
Representative Haddad, Representative Hoxa,
Hawk says yes.
Representative Johnson,
Yes.
Representative Menapace,
Yes.
Representative Rosario, Representative Santiago,
Santiago, yes.
Representative Shannon,
Shannon votes yes.
Senator Winfield,
Senator Winfield, in the affirmative.
Thank you, Mr. Chair.
Thank you, Mr. Clerk. Next up on our agenda, we have item number 7, SB number 1232, an act implementing the recommendations of the Risk Limiting Audits Working Group. Chair will entertain a motion. Moved by Senator Flexer, seconded by Representative Morin-Bello. This is a bill we've had several years now. It is quite fulsome, but it contains the recommendations of the Risk Limiting Audits Working Group, and those recommendations as screened and advised by the Secretary of the State's office. In short, this would set forth a procedure for risk limiting audits of our state elections for presidential electors, all applicable state offices, at least one representative in Congress, at least 5% in the aggregate of the offices of state senator and state representative, and any other position. Oh, actually, sorry, I'm going to withdraw this motion. I made a mistake. So we're going to remove the motion. All right, so we're going to move this over again. The chair forgot to announce that this was going to be a JFS to the floor. So item number 7 on our agenda, Senate Bill number 1232, an act implementing the recommendations of the Risk Limiting Audits Working Group. This is a JFS to the floor of LCO number 5594. The chair will now re-entertain a motion. Moved by Senator Flexer, seconded by Representative Morin-Bello. And as I was just describing, this would essentially institute and implement risk limiting audits for a number of state offices, essentially to make sure that the counts for those elections are correct and that our election results are reliable. This is a bill that we have worked on bipartisanly for several years now in coordination with the Secretary of the State and other stakeholders, and I urge my colleagues to support it. Is there further comment from the committee? Representative Mastrofrancesco.
Thank you, Mr. Chairman. Yes, I do agree. We've been trying to get this bill passed for the past few years. What the substitute language does, if you can concur with me, that it's actually going to move up the date from when this starts. Is that correct for you?
I believe it moves it back, Representative.
It's going from 2026 to, it's supposed to, the original bill was to start in 2026. This one is going to move it to 2027. I guess that's what I meant to say. Is that correct?
That is accurate, Representative Tew.
Is that right? I'm just curious why the move. For you, you can give me an explanation.
To you, Representative, that was at the request of the Secretary of the State's office to make sure that the requirements that would be put on them were properly administrable to you. And Senator Flexer will add, my co-chair will say so.
It's basically last year's timeline gave a year and a half. And so to have the bill be identical to last year, it moves it to 2027. So they still have a year and a half.
Okay, thank you for that. Thank you.
Thank you for that additional context, Madam Co-Chair. Representative Master Francesco, did you have further comment or question? Thank you. Senator Sampson.
Thank you, Mr. Chairman. I'll just reiterate your comments. I think that this is something we've been trying to do for the last several years. I would like to see a far more robust effort to clamp down on our election integrity. But this is definitely a step in the right direction and something that I've supported the Secretary of State on since we began this conversation a number of years ago. And risk limiting audits are a good start. I'll just leave it right there and say I'll support this bill for sure. Thank you.
Thank you, Senator Sampson. Further comments from the committee? Seeing none, Mr. Clerk, would you please call the roll?
This is a roll call vote for Senate Bill 1232, an act implementing the recommendations of the Risk Limiting Audits Working Group. The motion is to JFS LCO number 5594 to the floor. Senator Flexer. Representative Blumenthal.
Yes.
Senator Honig. Representative Morambello.
Yes.
Representative Osborne.
Yes.
Senator Sampson.
Sampson is yes.
Representative Master Francesco.
Yes.
Representative Bronco. Representative Carpino. Representative Fonsello.
Yes.
Representative Gauthier.
Gothier, yes.
Representative Haddad. Representative Hoxa. Representative Johnson.
Yes.
Representative Menapese.
Yes.
Representative Rosario. Representative Santiago.
Santiago, yes.
Representative Shannon.
Shannon votes yes.
Senator Winfield.
Senator Winfield, in the affirmative.
Did you want, I didn't get your vote, Representative Hoxa. Did you?
Voting yes.
Okay.
On number
Thank-
7. Yep.
Thank you. Thank you, Mr. Chair.
Thank you, Mr. Clerk. Next up, we have, excuse me, item number 8, Senate Bill number 1233, an act exempting the name and address of an individual reporting on an allegation involving bigotry or bias and of the alleged offender from disclosure under the Freedom of Information Act. This is a bit of a head fake. I know that JFS was distributed, but this is going to be a JF to the floor. The chair will entertain a motion. Moved by Senator Flexer, seconded by Representative Morambello. Is there further comment on this bill? It does basically exactly what it says it does. Senator Sampson.
I just can't resist making a comment about head fakes and moving and removing. I don't know if removing is the same thing as moving again, but we did get through that, and it was excellent. I certainly support this bill. I remember from the last session, and I will mention that this bill is another one that there's a similar version going through government oversight. Again, I don't know why that's happening, but nonetheless, I think this is a good policy, and looking forward to supporting it. Thank you.
Thank you, Senator Sampson. Further comment from the committee? Seeing none, Mr. Clerk, would you please call the roll?
This is a roll call vote for SB 1233, an act exempting the name and address of an individual reporting an allegation involving bigotry or bias and of the alleged offender from disclosure under the Freedom of Information Act. The motion is to JF to the floor. Senator Flexer. Representative Blumenthal.
Yes.
Senator Honig. Representative Morambella,
Yes.
Representative Osborne,
Yes.
Senator Sampson,
Senator Sampson is yes.
Representative Master Francesco,
Yes.
Representative Bronco,
Yes.
Representative Carpino, Representative Fonsello,
Yes.
Representative Gauthier,
Gothier, yes.
Representative Haddad, Representative Hoxa,
Hoxa votes yes.
Representative Johnson,
Johnson is yes.
Representative Menapace,
Yes.
Representative Rosario, Representative Santiago,
Santiago, yes.
Representative Shannon,
Shannon votes yes.
Senator Winfield.
Senator Winfield, in the affirmative.
Thank you, Mr. Chair.
Thank you, Mr. Clerk. Next up, we have item number 9, Senate Bill 1234, an act making certain terms in electronic book and digital audiobook license agreements or contracts unenforceable. This is a JF to the floor. The chair will entertain a motion. Moved by Senator Flexer, seconded by Representative Osborne. This bill would bind libraries receiving state funding in our state and prevent them from agreeing to certain onerous ebook and audiobook license provisions that have been imposed on them by publishers across the country. This is something we've heard from a lot by our libraries, essentially that they're being forced to agree to provisions that limit their ability to develop and hold consistent collections, that force them to rebuy audio or ebooks every 2 years or 26 borrows, whichever comes first, that prevent them from sharing information about the deals they make with other libraries. And this bill, rather than taking any action against the publishers, would simply bind libraries in this state to prevent them from agreeing to these onerous and frankly wasteful provisions that cause undue taxpayer dollars to be spent on them. Is there further comment on this bill? Senator Sampson.
Thank you very much, Mr. Chairman. I appreciate your description of the bill. I would start by saying that I don't think the title is accurate any longer because effectively this does not make terms in those contracts unenforceable. It really, this version of the bill simply seems limited, as you mentioned, to restricting the state and these libraries that are publicly funded from entering into certain contracts, which obviously is a policy decision that can be made by the government. And I got no objection to it from a legal standpoint. Previous iterations of this bill attempted to put restrictions on the entities that were selling ebooks to the state. And that I had an objection to simply because I believe it was unconstitutional and violated, the sanctity of private contract and the freedom to negotiate. This bill doesn't do any of those things, so I find it a lot less objectionable. However, I still don't support it on the grounds that I don't think that it's beneficial for the state to make such a policy decision. I believe that ultimately these folks, these publishers that produce these digital audiobooks are not likely to change the provisions in their contracts to satisfy these requirements. And therefore, libraries in the state of Connecticut will end up losing out on these the potential to make these purchases. I also, I just want to say, just in reaction to the chairman's comments and some of the testimony we've heard on this, including in prior years, I don't see the way these digital publishers are offering their product to be unreasonable in the least. The fact of the matter is that at the end of the day, digital audiobooks are produced by artists, authors, people that are compensated based on how many people ultimately purchase their product and read their writings, etc. If you make it so their digital versions of their work are widely dispersed and they're not compensated to the same degree they would be for an individual purchase, you're effectively harming the producer of the work to begin with, in my view. And I just don't think that's a reasonable tact. I wish I could remember some of the numbers that were thrown about because I was actually surprised how reasonable it was to actually sell a license to a library that could be reused many times, and yet the price that was being charged was only a small factor over what an individual copy cost. So with all of that, I'm like I said, I'm gonna vote no to the bill. Although I do have one question, I think I should ask just for the record, and that is in lines 18 through 25, subsection 5, it defines library, and I just want to make sure that this definition does not include any private libraries that might have, well, again, it says public library and publicly funded libraries. So I assume that leaves out a private library, but there may be some entity that is categorized as a private library that receives a very small amount of public funding. Maybe the chairman can reassure me that we're not venturing into harming people that own their libraries primarily through private funds. Through you.
To you, Senator, thank you for the question. This provision indicates that the definition of library under the bill, so libraries that would be bound by the bill, are libraries that receive public funding or in whole or in part in the previous fiscal year. And so it would not apply to private libraries that receive no public funding or no public funding in the previous fiscal year. But it would, or excuse me, sorry, the previous fiscal year or the current fiscal year succeeding. However, if libraries do receive such public funding, then they would be bound by the terms of this bill. To you.
Thank you very much, Mr. Chairman. Yeah, no, I mean, that's mildly concerning. I don't have any area of expertise or special knowledge about any particular library entity that I have any genuine concern about, but I do believe that that is somewhat broad. And I'd hate to see a private library that receives a tiny, token amount of public funds in the form of a grant or something like that be subject to these terms. So that gives me just another reason to object to this bill. Maybe that's something we can talk about, because I don't know that that's really the intent of the proponents of the legislation either, to get in the way of a private entity from making such a purchase. Of course, obviously it would be up to a private entity to decide whether they would continue to seek a grant or any public funds in the future if this was objectionable to them. So I do believe they have that option as well. So thank you very much, Mr. Chairman.
Thank you, Senator. Further questions or comments from the committee? Representative Mastrofrancesco.
Thank you, Mr. Chairman. I agree with Senator Sampson, and I concur with what he said. But I do have a question, and what really concerns me about this is that, one, I think this should just be a policy with the libraries if they choose to do so. Not necessarily that we need to have a law, but what really concerns me, we have a lot of debate going on this year about libraries. And should a publisher decide not to change their terms and conditions, what is our backup plan so the libraries will have access to ebooks? I don't see any provision in here that allows them to go outside the scope. It's possible, we don't know, but they may just say, you know what, we're not doing business with the state of Connecticut. And then what is our libraries to do? Through you, Mr. Chairman.
Thank you, Representative, for the question. And, that's something we've been thinking about. The consensus among market participants is that based on past actions and interactions, that rather than losing the business of the entire state of Connecticut, these publishers would choose to deal on a more fair and reasonable basis with our libraries. That being said, there have been conversations about potentially making the effective date on this bill different, perhaps through a longer effective date or making it a so-called trigger law, so that if other states that have considerable population and buying power choose to adopt similar measures, then our measure will spring into effect. So ultimately, I guess I would say our belief and our consensus is that rather than losing the business of the entire state of Connecticut, the publishers would choose to make a quite reasonable accommodation that would still allow them to profit handsomely from the relevant works. But there are other options on the table, and of course, the proponents are always willing to discuss them. To you.
Thank you. Thank you for that answer, Mr. Chairman. So based on this, it'll be effective July 1st, 2026. I think if I'm reading that correctly. And it just sounds to me that the state is passing this, is willing to take that risk with no backup. I don't know what the publishers will say. It's certainly their choice, and if they choose to comply, that's their choice. And I certainly like to leave it with that, but I also like to have a choice with the libraries for them to make their decisions. It's just concerning that there's no provisions in here for, like you talked about, a trigger or something. It will be interesting to see what the publishers do on this. So for that reason, Mr. Chairman, I'll be a no. Thank you.
Thank you, Representative Mastrofrancesco. Further comment or question from the committee? Seeing none, Mr. Clerk, would you please call the roll?
This is a roll call vote for Senate Bill 1234, an act making certain terms in electronic book and digital audiobook license agreements or contracts unenforceable. The motion is to JF to the floor. Senator Flexer,
Yes.
Representative Blumenthal,
Yes.
Senator Honig, Representative Morambello,
Yes.
Representative Osborne,
Yes.
Senator Sampson,
Sam says no.
Representative Mastrofrancesco,
No.
Representative Bronco,
No.
Representative Carpino, Representative Fonsello,
No.
Representative Gauthier,
Gothier, yes.
Representative Haddad, Representative Hoxa,
Hoxa votes no.
Representative Johnson,
Yes.
Representative Menapace,
Yes.
Representative Rosario, Representative Santiago,
Santiago, yes.
Representative Shannon,
Shannon votes yes.
Winfield.
Senator Winfield, in the affirmative.
Thank you, Mr. Chair.
Thank you, Mr. Clerk. Next up, we have item number 10 on our agenda, Senate Joint Resolution 35, resolution proposing a state constitutional amendment concerning discrimination on the basis of sex under the Equal Protection Clause. This is a JF to the floor. I will entertain a motion. Moved by Senator Flexer, seconded by Representative Shannon. This resolution does what it says. It would constitutionalize our current state statutory protections for reproductive health care and LGBTQ rights, in particular gender identity, and put them before the people for whether they should be included in our state constitution. Is there further comment on this resolution? Senator Sampson.
Thank you very much, Mr. Chairman. Obviously, this is a sensitive topic. This is not the first time that we've seen a similar constitutional amendment before this committee. We debated it at some length last year. I'll note that the public hearing that we had, I think, was a lot different this year than in the previous session. I think the majority of folks that showed up in 2024 were concerned with the question about pregnancy and abortion, whereas this year the focus at the public hearing, well, it was certainly mentioned, of course, I think was much more on the subject of gender identity, gender affirming care, things like that. So it's very interesting how just within a year, virtually the same bill has gotten a little bit different reaction to it. Generally speaking, I enjoy this committee and we cover a lot of important issues here. And as you can see, I think it's a mixture of bills that you'll find leave here unanimously, and some that have certain objections from the minority. The one thing I would say is that I do have a frustration when we come across bills that I think are less about good government and policy, where we can have natural disagreements just about where we differ on what the role of government might be, and things that I think are wholly political. And I view this in that light. And certainly the chairs might disagree with me. But when I see a bill like this, I feel like this is using a bomb to drive in a nail. We certainly want to make sure that there are protections in this world for people to live their lives as they choose. I would start this conversation by saying that there certainly should be, and I believe are, protections for people to exercise their right to make choices about how they pursue their happiness, given the words in our declaration, when it comes to their gender identity and so forth. You're going to come up against some conflict and disagreement when you start to get into the arena of children. And more importantly, the areas where those rights might conflict with other rights, religious liberty, association, and so forth. And so I've got a number of questions today and some comments, and they're all based on those conflicts, more or less. But I want to stress at the outset of this conversation that, and I don't want to speak for other people, but I think it's safe to say that folks on the Republican side in this committee are every bit as concerned about protecting the rights of every individual in the state to live as they choose. And it's a frustration when bills like this are used to mischaracterize the position of Republicans or the minority as somehow bigoted against the transgender community or what have you, because it's just not true. I would defend the right of anyone to live their life as they choose. I'd stand in front of a bus to protect someone's right to be able to live the way they want to. And this bill, in my view, does not get you there. And I'll also point out, this is a constitutional amendment. I suppose we should consider ourselves somewhat fortunate that there's only one constitutional amendment on this agenda. In previous years, we've had 2 and 3 constitutional amendments at a time. I view the state and federal constitution as somewhat, sacrosanct. That's not to say that we can't change it. It's, designed to be changed via amendment. But I believe that those amendments should be few and far between, and they should be done for very important and legitimate reasons. Nationally, we've made constitutional amendments to make significant corrections in the way our government was established from the outset. Providing and protecting the rights of women and minorities and former slaves to vote, just for example. I think these are things that were laid out in the founding documents of our country as our goals and purpose, but it took time for them to be achieved through our system of laws and justice. I see people promoting this bill as if that's kind of the same issue here, but I don't think it is at all. I believe that folks have the right to their gender identity and expression. We've already decided to protect it in our state statute. The question is, what happens when you create such a right in a constitution and that now has to be tested against other rights? As I mentioned, religious liberty, probably chief among them. So I think I'll start just with the language that's in the bill. For the record, this is Senate Joint Resolution 35. It would be a change to our Constitution. The process would be that if this passes this committee, it would go to the House and Senate. If it passed by I think it's a 2/3 majority in one, it's 3/4 majority in one session, it would then go on the ballot for the people of Connecticut to vote on, and if passed, would become a part of our Constitution. If it did not pass by a 3/4 majority, but passed only by a simple plurality in both chambers, it would require it to be voted on again in a separate legislature. And because we're in the first year of a biennium, it would have to wait until the first year of the next biennium. And there, same thing. If it passed twice with a simple plurality, or if it passed by 3/4 the next time, it would then go to the voters. That's the process to pass a constitutional amendment. the bill that is in front of us contains a couple of things. It contains the language that would show up in the Constitution if it were passed by the legislature and by the voters. And it also, interestingly, includes the question that would be asked to the voters, which, you know, in regards to some of the other constitutional amendments that have gone through the legislature since I've been here, has always been, you know, maybe the greatest bone of contention, which is what goes before the voters. What are you actually asking them? And is it clear what your intent is? I objected to the question on early voting because it didn't say how much early voting. Is it 1 day, 5 days, 1,000 days? And as a result, I don't know that we got an accurate response from the public, because I think if people knew the exact number of days, they may have voted differently, maybe not. But I can tell you that the number of days definitely mattered to me, and probably did matter to a number of people that were voting. Not to get sidetracked on that, but I was just pointing out that the question is definitely an important part of this conversation. So the language that would be added to our existing Article 21 of the amendments to the state constitution would be to add to the pre-existing protection for ancestry, religion, race, color, national origin, sex, or physical or mental disability, would be a clarification that would say, as used in the section, discrimination in the exercise of enjoyment of civil or political rights because of sex, which is already listed, includes but is not limited to discrimination in intent or effect based on pregnancy, including preventing, initiating, continuing, or terminating a pregnancy. And then it goes on to say sexual orientation, gender identity and expression, and also related health care. So you can see there's a lot there to get through, and each one of those words critically important to understand the ramifications of their inclusion in this Constitution going forward if this were ever to happen. So I guess I want to start with the abortion question, since it's listed first, and maybe the something we're more familiar with because we've covered that ground, I think, extensively in the past. Through you, Mr. Chairman, the first question I have really is, if this were to pass and become the law of the land and part of our Constitution, would existing Connecticut statutes that limit abortions based on viability, period of gestation, would those continue to be law, or could they be challenged based on this new wording in the Constitution? Through you.
To you, Senator, the current laws on the books would not be unconstitutional that you mentioned under this provision. To you.
Thank you, Mr. Chairman. I appreciate the answer to the question, although I don't know that you've got the authority to determine that on your own. I was hoping you would answer, in my view, more appropriately to say that would be a question ultimately before a court. I sensed you were not going to disagree with me that the new constitutional amendment would simply throw those things out. I believe it would, and I believe that a court would agree. But would you disagree with me that ultimately that would be a question before a court if somebody chose to challenge our existing limits on viability, for example, through you?
To you, Senator, I acknowledge and agree that a court would ultimately make a decision about the meaning of this constitutional amendment if it were to pass. However, one of the chief things that the court would consider would be the intention of the legislature when it passed the measure and sent it to the people of Connecticut. And as a result, I'm expressing that intent that this would not render those statutes unconstitutional. To you.
Thank you very much, Mr. Chairman. I appreciate that. I think that the court would potentially take into consideration your commentary as something to do with intent, although I don't think they would rely simply on the House Chairman of the GAE committee to determine intent. I think they'd also recognize my comments about the way I read the intent of the bill. And I'd say more important than that, I've seen over and over how the court is utterly and completely ignored the intent of the legislature. I would use the repeal of the death penalty prospectively as the key example in that argument to say there was countless hours of debate about how the death penalty would be repealed only prospectively, but then ultimately was challenged on that notion immediately, effectively. How about other things like potential future restrictions on abortion, a prohibition that the legislature would pass, say, restricting late-term abortions? Would that ever would that stand the scrutiny of this constitutional amendment? Through you.
To you, Senator, the question of whether those restrictions could withstand scrutiny under this amendment, should it be passed, would be one where the court would look to see whether the suspect class and suspect category that was being impacted was discriminated against, whether the impact, or I guess the one sec, I'm blanking on the word, whether it would be under strict scrutiny. Essentially, the court would be looking to the legislature's intent and whether that intended goal was one that was a compelling interest. That was the word I was searching for. And whether the law that was ultimately passed to protect that compelling interest was narrowly tailored to protect that interest and to avoid any undue discrimination outside of it. To you.
Thank you very much, Mr. Chairman. I appreciate the answer. The constitutional amendment is quite explicit. It says very clearly that this language would define, or I'm trying to get the language back on my screen, and of course it's fighting me. But it says that, thank you very much, Representative. We take the other portions of the 21st or Article 21 of the amendments to the Constitution quite seriously, and I think that they are clear on their face. I think more likely a court is going to, when it comes to interpreting the Constitution, going to use the plain language that is here, and I suspect also, not in small part because of the testimony that we heard from people both in favor and opposed to this potential constitutional amendment, that this would, in fact, protect abortions up until birth. And this is a moral concern for some of us. I identify as pro-life, but I would say the majority of people in the state even that might identify as pro-choice. And I just frankly say that those words, I think, tend to have less and less meaning all the time. I think most of the people that I know, even if they identify themselves as pro-choice, are not in favor of abortion particularly. They'd like to see as few abortions exist as possible, and they'd also like to see them happen very early on in a pregnancy. And the argument would be, that, as a pregnancy progresses, you're talking about a more and more developed human being. Now, the old adage about how it's above my pay grade to determine when life begins, but many people, leaving me out of it, believe life begins at conception. And I think there's very, very few people that would say life begins at birth. I think most people would acknowledge that life begins at some point prior to birth, especially since we have folks that give birth prematurely. I wouldn't say that the people that are born prematurely are not alive. So based on that level of or lack of clarity about when life begins, but the absolute concern that it begins at some point between conception and birth, you can make the conclusion that some people are obviously going to object to ending a life. So through you, Mr. Chairman, Do you see that other restrictions that might be contemplated by this legislature, for example, parental notification or consent, something that I proposed year in and year out, would a policy like that come into play? Would that be measured against this constitutional amendment through you?
Through you, Senator, yes.
I imagine you would say yes, and I have the same opinion as the previous conversation, which is that I'm pretty certain that if that's the case, then I think that a court would have a very, very difficult time allowing a parental notification law in the state of Connecticut to stand, uh, based on the fact that we are establishing in our constitutional framework what appears to be a protected right to abortion without any restrictions. How about people that are maybe what I consider to be conscientious objectors? How does this bill reconcile these expanded abortion rights with healthcare providers that might have religious or moral objections? Through you.
To you, Senator, it does not deal with non-state actors who might have such objections to you.
Thank you for the answer, Mr. Chairman, but I don't know if I understand it or not. I mean, these are things that are going to happen in the world. You're going to have a healthcare provider, but maybe a religious one, or someone that simply refuses to perform an abortion because of their own beliefs. Will they? And they could be sued for that. Nothing would stop them from being sued today. But the difference is that if this constitutional amendment passes, that's going to be the question the court has to weigh, whether or not this person's religious freedom is in conflict, which clearly it will be, with the rights guaranteed under this revised amendment. So what happens in that case is what I'm asking. I mean, which right is going to prevail? Is it going to be the religious freedom of the healthcare provider or the right of the person to have an abortion without limitations? Through you.
To you, Senator, it would depend on the circumstances, but I don't believe that this amendment would have any impact on that beyond our current laws. To you. Or excuse me, beyond statutory law as it exists now or in the future. To you.
I appreciate the answer, although I'm very surprised by it, and I don't think that. I guess I have to simply disagree with my colleague that I foresee a court having a tremendous struggle with trying to determine where the boundary would be. Take a faith-based hospital. I can just imagine the series of circumstances, and I'm just coming up with one potential case, which is a person looking or seeking an abortion from a religious provider. But I think there's probably countless other examples where religious freedom would come into conflict with expanded abortion rights. How about if we just talk about the gender identity question just for a second? Can you just describe for me, since there's no definitions in our Constitution, when we write a statute, we provide definitions for things. What guidance will a future court have when faced with the language that is in this constitutional amendment describing gender identity and expression? Through you.
Through you, or to you, excuse me, Senator, the plain language of the text and the social understanding at the time, including U.S. Supreme Court decisions on the subject, including on Title VII, finding that gender identity is protected as a part of anti-discrimination provisions that prevent discrimination on the basis of sex at the federal level. To you.
Thank you very much, Mr. Chairman. I appreciate the answer, but I don't know that you really answered my question, which is, since there's no actual definition in the Constitution, how is the court going to interpret those words? Are they going to look to our state statute? Are they going to Google it? what's going to be the way that they define what someone's gender identity or expression is?
To you, Senator, they would look at I think most likely at the public meaning at the time of the passage, including common sense definitions, dictionary definitions, definitions in other legislative provisions, and in other court decisions, including, one moment, please, I'm looking at the actual court decision. Bostock versus Clayton County, which was decided in 2019. To you.
All right, thank you very much for that answer. I'll tell you, as somebody who has served in the legislature since 2011, which I believe it was 2011 or 2012, that the current current state statutory protections were added covering gender identity and expression that I remember asking on the floor of the House at the time, and I don't recall getting any real concrete answer. In fact, the definition in the statute effectively is a circular argument saying, well, gender identity is gender identity and gender expression is gender expression. It doesn't actually say much more than that. I think there's definitely an issue with clarity about what those terms mean. But adding these protections that are included in this language, which includes sexual orientation, gender identity and expression, and related healthcare, would that related healthcare include what has been referred to by some of the folks testifying and in the various medical providers as gender affirming care? And I'll just ask the next question too, which is, does that include reassignment surgery as well through you?
To you, Senator, it would include gender affirming care to the appropriate medical standard of care, and to the extent that that included and approved of gender reassignment surgery, that would be included to you.
So based on that, would that prevent a insurance company, for example, for suggesting that they don't cover those types of medical procedures or medications through you?
To you, I believe it would depend on the circumstances if I understand the senator's question correctly. It would depend on whether there was an element of state action, and it would depend on the circumstances, including whether those policies were discriminatory or were targeted at a compelling state interest to you.
Thank you very much, Mr. Chairman. I appreciate the legalese in your response, and I get what you're saying, but I'm trying to put this in more real world terms, which is these things are going to happen. These questions are going to come up. There is going to be debate over whether or not certain medical procedures are medically necessary. And if anyone disagrees that gender reassignment surgery, for example, is not medically necessary based on moral or religious or even scientific grounds, would they be considered to be discriminating based on the language in the revised constitutional amendment?
To you, Senator, if their decision was in accordance with the relevant standard of care, no.
Who determines the relevant standard of care through you, Mr. Chairman?
To you, Senator, the medical providers who are in a similar specialty providing that same care to you.
Through you, Mr. Chairman. So in effect, what you're saying is that to reach the level of discrimination, in your view, a court would be measuring whether or not this particular medical provider was dissenting from the association's view that they belong to, or for the majority of comparable providers. Am I reading that correctly through you?
To you, Senator, it's a little more complicated than that. It would basically be whether most likely be whether the decision by the provider was within the appropriate and reasonable decision-making of a provider in the same specialty or subspecialty, depending on the case. And if there were disagreement within reasonable providers in that specialty, then it would not be discrimination. If it were not within that scope, it could potentially be discrimination, depending, again, whether there's state action and depending whether there was an intent for discrimination or there was an indicate, or depending on the evidence about whether the decision were narrowly tailored to the compelling state interest. To you.
Thank you very much, Mr. Chairman. I appreciate your answer because I think you are illustrating for anyone listening just how, I would say, diabolical this policy is. You know, our constitutional framework, both on a state and federal level, is designed to protect individuals. That's why we have a Bill of Rights, for example. That's the whole concept of America, that we don't govern by groups. We protect the rights of individuals to pursue their happiness. I open my remarks by expressing my desire to see people that I don't agree with necessarily live their lives as they choose, and for me and others to respect that right. And what you're suggesting is somehow this legislation, this constitutional amendment, is in effect going to be designed and used for the express purpose of preventing any dissent from within a medical community or even in society at large. If there is any particular religious sect that says that somehow this is wrong, they can be considered to be discriminating against this population or a specific procedure. And for me, that's like the whole point of my line of questioning, which is to illustrate that you are going to be challenging and creating conflict between different types of constitutional protections. Religious liberty is something the country was founded on, where there is key elements in our state and U.S. constitutions to protect that right to individual religious freedom. And we've had many decisions decided on the subject of protecting someone's individual right to religious liberty. And I believe that's out the window when you start to measure whether or not they are using their religious liberty in an act of discrimination. I think that is toxic and dangerous to the nth degree. And I also think it has so little to do with what has been sold to the people that came to testify. The people that came to testify to us were concerned about making sure that they were not going to be targeted by an administration or by laws or by fellow members of the community in a negative light. But what this bill or constitutional amendment would do, it may add to those protections, which I would argue already exist. It would now say that anyone who disagrees with you is now someone who is subject to harm. I find it overwhelming, to be honest with you. Consider all of these different times this is going to come up. You know, if a doctor refuses to perform a gender affirming surgery because of their religious belief, now if they're the only one in the in their group that feels this way, are they potentially likely to lose their license to practice medicine based on your previous comment, Mr. Chairman?
To you, Senator, the answer to your latest question is no. And just to clarify my previous answer, because I think I probably was unclear. Again, this provision would require some element of state action to apply. It does not apply to every individual private actor in the state of Connecticut. It limits the state's ability to discriminate, whether through the legislature, through the executive branch, through other state actions to discriminate on these bases. To you. Just add, sorry, that there is existing U.S. Supreme Court precedent protecting the rights of individuals under the First Amendment to declined to provide certain care that's in conflict with its religious dictates. I'm pointing specifically to the Little Sisters of the Poor case, which was decided in, I believe, 2020. To you.
Thank you, Mr. Chairman. I appreciate that, except this constitutional amendment is not limited to the acts of government. I mean, the constitutional amendment that we are modifying is about preventing discrimination based on civil and political rights, religion, race, color, ethnicity, origin, etc. I mean, those things don't just apply to the government. They're telling people on the street that you cannot deny someone access to a facility, for example, based on these different factors. That's what the civil rights protections in our Constitution do. You're adding a civil rights protection that says that you cannot be discriminated against either, and you're adding it to the point where you cannot be told that you cannot have gender surgery. And therefore, you are creating a person who has violated the Constitution by expressing their own religious freedom. That's what you're doing. That's the objection that I'm expressing, and I'm really searching for a legitimate response to that. I think you basically gave me that answer yourself, that's how this works. Your reaction, through you.
To you, Senator, I guess I disagree with the good senator's characterization of the meaning of the resolution. If my previous answer was unclear or I mistakenly referred to something other than that I'm referring to now, I apologize, but I don't believe that the good senator's characterization of the meaning and intent of the resolution is correct. To you.
Thank you very much, Mr. Chairman. Forgive me, I was just relying on what I heard. Again, I have no desire to mischaracterize what you said. I just interpreted what you said, and I think as accurately as you said it. And you and I are not the deciders in this conversation anyway. I think that you and I have a role to play to potentially flesh out the arguments that might be made down the road if this was ever to become part of our Constitution and this was going to be before a court of law. And I take it immensely seriously. I mean, obviously, I take every bill that we vote on as very serious. We're making laws. We're not just, as I described, playing politics. We're here creating policy that the people of Connecticut are going to have to live under. And I'm afraid we pass far too many laws that are not fleshed out thoroughly enough to avoid negative consequences. And we are often back here fixing things the next year. But in this particular case, we're talking about a constitutional amendment. And in that vein, I think we have to be just that much more vigilant about making sure we ask these questions, these hard questions, to get at what's really going on and how it's going to impact the people of our state. Can I ask you a question also, Mr. Chairman? You alluded to whether or not something was widely accepted in the medical community as an example, but it could be a lot of things. When you say that, does that mean just in Connecticut? Because this amendment will affect the state of Connecticut, but we are a nation of 50 states, and not all of them will have a similar constitutional amendment. And I would suspect that the objective view of certain medical procedures in different states is going to vary wildly. So when you say whether or not something is considered to be out of the norm for the peer group, is that peer group limited to people within the state of Connecticut, through you?
To you, when there's a reference to the standard of care in our current statutes, it's generally a national standard of care. It's mostly referred to in the context of medical malpractice. This resolution would not mandate a specific standard of care. The point of this resolution and the intent of this resolution is to protect care that is accepted by reasonable providers in the relevant area, and not to demand that any care have to be provided if it is not considered reasonable by providers in the relevant area. To you.
I appreciate that answer, although I don't know that it clears up my concern any further. I wrote down last night, I stayed up late and I kind of tried to put together as many questions as I could find where I thought that there might be a potential conflict between religious liberty and this proposal, as well as, you know, the rights to freedom of association. I imagine that there may be even other areas of constitutional protections where there's going to be a rub between this new series of protections against discrimination. Certainly can come into conflict. You know, it's interesting, just I'm thinking about this while we're talking about it, that the existing Article 21 chooses the protections against discrimination very carefully to things that are completely and utterly societally you know, predetermined or backed up by our culture. You know, we as a group, with very, very few exceptions, believe that it is wrong to discriminate against someone based on their religion or their race or their color or their ancestry or a physical or mental disability. That's something that I think is universally held, and that people that attempt to go around that are going to immediately find themselves in trouble when it comes to the respect and view of their peers generally. And then to create a constitutional amendment surrounding that to establish it, I think makes perfect sense. And that's why we have Article 21 that we do now. I do not agree that positions that are extremely controversial, like abortion in general, and more specifically, and particularly more concerning to me, is abortions that might occur at the very end of a pregnancy in the final moments, or things such as gender assignment surgery for children. Those are things that I do not believe are socially acceptable by a majority, let alone a plurality. And yet those protections are being attempted to being inserted with other things that are understood to be almost universal. And I guess that's the issue I have with this. I don't think you can equate the idea that someone might say that I don't agree with late-term abortion, and I don't agree with gender assignment surgery on children as something that is as disgusting as suggesting that I don't like people because of their race. But that's in effect what is being done here. And I wonder if the good chairman disagrees with me in my assessment of just how different those things are.
I'm not sure if the question is entirely appropriate because I think it's kind of calling for my opinion, but I will, I'll answer, I think, in the spirit it was intended, which is, I guess, more broadly, how do we determine whether these rights are ones that the people of Connecticut believe should be broadly protected? And I think the answer to that is relatively simple. We put a constitutional amendment before them, and they get to vote whether they believe these rights should be protected. And I think just more generally, one of the reasons why this constitutional amendment is being considered and why it may be helpful and protective for individuals in this state is because while we have strong statutory protections already for reproductive rights and for gender identity and for other LGBTQ rights, those statutes are not set in stone. And we've seen other states across the country who, as recently as 20 years ago, were leaders on LGBTQ rights. For instance, Iowa was one of the first states to acknowledge a right to same-sex marriage, go back on those rights. Just in the past few days, Iowa has had its legislature pass laws that would strip uh, transgender people of all civil rights protections. And so I think the intent of this provision is to, first of all, allow the people of Connecticut to determine by using their voices whether they agree with the good senator's position or with an alternative position. And also, if they do agree that these rights should be protected, that these rights be protected more permanently and reliably, and that people in the state should have a an ability to know that they can depend on them for the longer term. To you.
Thank you, Mr. Chairman. You know, my issue with is that I think something is definitely being lost in translation. The issue I have with this is that this constitutional amendment language is written in the most deceptive manner possible, and it is even being marketed in an even more deceptive manner. You cannot equate protections for gender identity and expression and even the quote unquote right to have an abortion with discrimination against those things. And that's what is being done here. You know, to say that you should not be able to discriminate against someone for their gender identity and expression is different than saying that someone has a right not to be discriminated against gender surgery. That's not the same thing in any way, shape, or form, but that's what's being added here. It says that you are creating in our constitutional framework a right not to be discriminated against based on your gender identity expression and related health care. And I don't believe that that is a widely accepted, universally appreciated worldview, as is other protections against the way people choose to live. And you're going to run into problems not only with religious liberty, but parental rights. For example, let me ask you a question, Mr. Chairman. Based on this notion of a right to be protected from discrimination against your desire for gender affirming care, for example, if a parent refuses to allow their child to transition, is that something that could legitimately be argued in front of a court? That a parent is defying the right of their child to do so and to not be discriminated against based on the text of the constitutional amendment before us? Could a parent lose their custody of a child over that through you?
To you, Senator, again, this would require state action, so I don't believe that that would be covered to you.
Yeah, thank you very much, Mr. Chairman. I appreciate you, and I know that these are impossible questions to answer, but the answer to every one of those questions is, well, it'll be up to the court. And the court is going to have to rely on the plain text of the constitutional amendment. And the plain text of the constitutional amendment for me reads that it protects abortion up to birth without any restrictions. It will immediately nullify any existing protections for based on viability or anything else that currently exists. The moment this happens, there will be challenges in court attempting to overturn those things, and they will be overturned because of the plain text of this document. I also believe that it is going to effectively mean that the view that transgender science trumps actual science based on gender being based on chromosomes, et cetera, will be out the window. And I am very concerned that these examples that I'm giving are not just in Never Never Land. They're the real things that are going to happen. You're going to have children who are identifying as transgender, challenging their parents for defying their right established in this constitutional amendment to transition. And I don't know what happens as a result. I don't think we should be having that conversation now. Would public schools be required to teach gender identity and sexual orientation in a way that conflicts with people that have a different view? Would religious schools be required lest they be considered discriminating because of this constitutional amendment? How about, biological men and women's sports? If you just come out and say that someone's gender identity is protected and you cannot discriminate against them, then I believe you are on its face precluding any sanctioning body from suggesting that it is inappropriate. Am I wrong about that, Mr. Chairman?
No, it would depend on the circumstances. The body would have to make a decision that did not discriminate with animus against individuals, and it would have to make a decision that was supported by a compelling governmental interest and was narrowly tailored to that interest. To you.
Thank you, Mr. Chairman. I appreciate the legalese, but I'm referring to the plain text of the constitutional amendment that is before us, which says you cannot discriminate against someone based on their gender identity. Well, if we interpret that the same way the other items are already included in the Constitution, like you can't discriminate against someone based on their race, I imagine a sanctioning body tried to tell someone that they can't compete in a specific sporting event because of their race, they're going to run into trouble based on that existing provision in the Constitution. And when you add gender identity to that, I believe you have just protected someone and allowed them to identify any way they choose. I haven't heard anything that would tell me otherwise, and to suggest that there's all these different mechanisms by which the court will have to weigh it. The number one way that they're going to interpret is the plain text that's before them, and they're going to have to be forced to interpret the things that we add in a similar way than the other items that are already included. I don't know how they could possibly get around that. I don't know if religious hospitals will be obligated to perform abortions. I don't know if they could be sued or fined if they choose not to. I don't know whether religious institutions will have to teach certain topics they disagree with or lose their ability to do so. I don't know if doctors that refuse to perform late-term abortions will lose their medical license because they go against the norms within the rest of the medical provider field. I don't know if private entities will be forced to honor the pronouns of people that come before them or be accused of discrimination. I don't know whether or not teachers in a classroom will have to acknowledge the identity or pronouns of students, or be condemned for discrimination or potentially sued or lose their ability to work because of that. All of these things, I think, are logical conclusions. I don't think anything I'm suggesting is any way a stretch. The way this is written is not just to protect the rights of the individuals to live their life as they choose. It also suggests that people that disagree with them because they have their own sincerely held religious and moral feelings on these subjects are not allowed to live their lives as they choose. And that's where you have a problem. Is we can only protect people's rights up until the point they become in conflict with someone else's rights. And the way this is worded is it's completely disregarding people with alternative views' rights. And that's what I find so shocking, because unlike race and religion, which are, as I said, universal in our desire to prevent discrimination, these other things are not the same. They are just not. There are good people that legitimately don't believe that children should be transitioning. And for the record, by the way, we heard a lot of testimony the other day about that exact subject, and it was brought forward many, many times by many people that that's not happening in Connecticut. And I just want to point out for the record that it absolutely is. We, in fact, had a session earlier this week in the House and Senate where money was granted to a number of entities as part of an emergency certified bill. And two of those entities are people that advertise that they do actually do perform gender assignment surgery, and they do work with minors. There's a website out there called stoptheharmdatabase.com, and if anyone's interested, they should go look there. This is a group that actually investigates this, and they do it by looking at the actual codes at which healthcare is provided. There's also articles in the CT Mirror that cite different medical institutions and providers acknowledging that they perform these surgeries. And I'm not going to go on any longer about it, but I wanted to at least say that there is documentary evidence that's been provided to me that's unequivocal, that it's absolutely happening in the state of Connecticut. It's not just some sort of fear mongering or something like that. It's actually happening. I'm going to kind of wrap up my comments, but I just want to, I guess, bring this back to the beginning of where we started. This job can be unbelievably frustrating at times because, you know, the media, while they attempt to do a good job, I think, in getting the gist of what we're debating in the legislature in front of people, often the details are not provided. Are you going to interrupt me, Mr. Chairman? No, I'm sorry. I see your hand on the button. I didn't know if I was violating any protocol or anything like that. Oh, I'm not that almost done, but I'm gearing up to the end. So the concern I have is that, you know, the media can't do the full job. You know, I might have been going on for, you know, some time here, but I don't think we've actually talked about this enough. I mean, this is a incredibly consequential decision that we are making about whether or not to venture down this road and make this change to our Constitution, which will have lasting impact. I mean, when something like this gets passed, it doesn't get unpassed very easily, and society will have to conform to it. We got to make a decision about whether that's a good idea. There's other civilizations that have predated us that made sweeping changes to the way people lived, and they ruined themselves in the process. I don't want to make sweeping changes to the way we govern ourselves and the way we live in a way that ends up harming our civilization. And I feel like this might just be something that does that. And what's frustrating is that, you know, everyone's jockeying for position when it comes to a political debate, because by the nature of American politics, you have to be elected to serve and debate these issues. So you're going to paint them in the most you know, biased possible way to benefit your position. I've always tried to be fair and suggest that, you know, I'm not perfect. I don't know everything. This is my position. I'll even volunteer as accurately as possible my opponent's position on things because I believe that it's best if people have the information and they decide for themselves. After all, that's our role as representatives. But this particular debate, I have to say, has been approached in the most deceptive and dishonest way. And I'm not trying to put that on the chairs of this committee or anyone else. I'm just suggesting that all of the conversation that was had during our public hearing and what I've seen shared by various interest groups is far from the truth. This is not a debate over whether or not people agree with the choice of people to transition or live their life as they choose. Everyone on this committee, and I would argue everyone in this legislature, agrees with that right. The questions come later. They're like, well, I don't disagree with someone wanting to identify a certain way, but do I think it's okay to have young children engaged in hormone therapy or even surgery? I don't know that that's a positive. We had some person testify. We had a lady who came on and described how her 1.5-year-old child was speaking about their not being comfortable in their body as a boy. If you are a parent of a 1.5-year-old child and you take that seriously and then take action with it, then I believe you ought to be in prison. The fact of the matter is, children that are so young have no concept of what even being a man or a woman is. And not to get into a side conversation about it, but this is something I asked a lot of folks that were here at that hearing outside. I was like, you say you're uncomfortable in your body as a man, and you feel like you maybe are more inclined to have been born in a woman's body, but how do you even know what that is? So again, I'm not trying to be disrespectful. I just think there are a lot of questions here and there's a lot of perspectives. And our job from our constitutional framework is to protect all those opinions. I don't want to see anyone treat anyone in a derogatory fashion, but I also don't want to see people forced to agree with things they don't agree with. I don't agree that you can change your gender. So I don't want to ever be forced to address someone that I believe is physically a male as a she. I don't want to have to do that. I don't want to stop that person from doing it. They can do whatever they like. But when you start to force someone else to have to ascribe to your view versus theirs, and I believe that's what this constitutional amendment does. It sets up the framework to prohibit people from being able to hold their sincerely held religious and moral beliefs in favor of the majority's desire to protect the rights of a small segment of the population. Those people's rights matter for sure, but they don't matter to the point of outweighing the rights of everyone else. There are competing rights at stake, and we absolutely have to maintain rights for parents to be able to determine what their children do. We have to protect the rights of people to express their religious and moral views without fear of being subject to the parameters of a new constitutional framework that says that if you disagree with someone's gender identity, that somehow you are guilty of discrimination the same way you'd be guilty of discriminating against someone based on their race. I think that is wrong. I think I'm going to leave it right there. I'll just finally say that I think this protection for gender identity in particular, I think the abortion issue, I think it was a separate thing that we covered, but the subject of protecting someone's gender identity is something that could be considered. But to put it in the larger framework of discrimination, I think creates the conflicts I spoke of. And for those reasons, I think it's bad policy, frankly. And I'll be a no today. Thank you.
Thank you, Senator. And I appreciate the Senator's views. And obviously, we disagree on both the meaning and intent of the resolution. But I just wanted to say for legislative intent that the intent of this resolution is not to elevate the right to be free from discrimination above any other constitutional right, but just for these additional clarified categories to make sure that those categories of discrimination or freedom from discrimination are considered alongside those other rights, and courts consider and balance rights all the time. And we may disagree with how they do so, but it is something we depend on our courts to do. With that, next up, Senator Winfield.
Thank you, Mr. Chair. And I don't know how much light I can shed on this, but I will start off with saying that I am in support. My memory is not clouded by myth of what has happened in this nation. I know that when the rights of folks like me prevailed in our Supreme Court, that folks did not just automatically turn over and universally accept it. As a matter of fact, I'll take you to the notion of the swimming pool in this country and the loss of the public swimming pool because folks did not accept those rights. And I will tell you that stemming from that, the conversations we've had for the last 6 decades have been what they are. stemming from that, people who in their religious beliefs did not even concern themselves with abortion began to concern themselves with abortion. The politics of this nation were shaped by a refusal to accept that people like me should have rights and be able to be next to folks in public accommodations, to the point where we have given up the public good so that we could make sure that we weren't together. And so we can make sure that even though the law of the land suggests that I am as human as anyone else and that I should not have to experience segregation and all of the things that we know, that though that may be the law of the land, there is a pushback and has been a pushback that has created the political climate that there is in this country today. So some folks in this country, a lot of folks in this country, have some sincerely held beliefs that would tell you, if they could have their way, that this person right before you should not have the rights that I do. Thank God that I have those rights. And then we go on to talk about folks who we don't even understand. I've listened to this conversation about gender and sexuality in the legislature for a very long time, and I've heard very little in terms of the opposition that suggests to me that we even understand what it is we're talking about. We put it in the context of XX and XY because that's the universe, except that it's not. We know that. And this isn't some left-wing attempt at recreating biology. We know that there's more than XX and XY. Yet we have refused to accept that even into the conversation. Wherever you come down after you accept the knowledge that we have refused to accept that. There's XX, there's XY, there's XXY, there's XYY, Klinefelters and Jacobs syndrome. There's all kinds of ways in which this chromosomal conversation manifests itself. And yet we still talk about it as if we have no knowledge of that, even though we've been having this conversation in the legislature for long enough that anyone who's been involved should know better. And even if you're not talking about that distribution, if you're talking about the gonadal distribution, that we used to talk about people as hermaphrodites, and thank God we progressed and we talk about them better as intersex, that those who have the XX chromosome will have the ovaries that they have and the ovotestes. That doesn't come into, those who have the XY would have the testes, right? And so the way that people feel about their body is not just a feeling, there is a biology to it, and we don't acknowledge that. And we have these conversations as if we're talking about this thing and it's just about the religious objection of someone, the what about me of someone. But we are not talking about the reality that these people experience. No one objects when a young 1, 2, 3-year-old boy says, I feel like a boy. But there are reasons why someone might feel like they're not a boy. And we take the simplest things and make them difficult because then we don't have to do the things that we don't want to do. To understand gender identity is not that hard. It's how I identify myself in terms of gender. It's literally written in the words. And gender expression is how it is expressed, how you receive it because of the way in which I express it. None of this stuff is super complicated. What's complicated is to get past where we have been. What's complicated is to get past, I should have a right to say no to you as you appear. And that's not just to the people who it's easy to see, well, they're a little different. That's the people who we pretend like we don't see that they're different anymore, like me. So maybe people don't want to vote for this, but let's not act like we don't know better, because we do. And maybe this time, folks who care about what happens to our future don't say, well, I'm not the one who can't swim in a swimming pool. I'm not the one who, when they throw the acid in the swimming pool, it affects me. I'm not the one who, when they take those swimming pools and they fill them full of concrete, it affects me. To the point where it is the genesis of why there's a difference between the rates of the ability to swim of Black folks and white folks. So let's not act like there's no difference. Still, even today, let's not act like there's not real consequences even today. The politics we have, the reason why a couple of years ago we had to come in and have a conversation about the right to abortion has its genesis in the swimming pool. It is offensive to hear that it is universally accepted that the rights that I thank God have are accepted by people, because they're not. So I will always stand and fight for people who are looked at as the outsider, because it's because people fought for people like me that I can even be here today. Thank you, Mr. Chair.
Thank you, Senator. Representative Gauthier.
Thank you, Mr. Chair. And thank you very much, Senator Winfield, for your comments just now. I'll be relatively brief. I take the plain reading of this text, SJ 35, to actually be quite straightforward. For example, as was brought up earlier, I don't understand, or I don't see the germaneness of our own personal views or our own personal beliefs on, for example, when life begins. Because that is not what we are dealing with here in this measure. And I'll read directly from the legislation. What we are dealing with here is no person shall be denied the equal protection of the law. That's what we're dealing with, the law. We are not dealing with our own or anybody's personal beliefs. We are also not dealing with anybody's religious beliefs. We are enshrining and protecting rights under the law. That is all that we're dealing with here. And again, I'll reiterate, I take the reading of this language to be very clear on that and very straightforward and relatively simple. So thank you for letting me speak. Thank you.
Thank you, Representative. Representative Johnson.
Thank you, Chair, for the opportunity to speak very briefly about this bill. I will have no questions. I just wanted to lift up some of the things that we heard together at the public hearing and speak to one aspect of this proposal in particular. And I'll say, with an indulgence of some of the fact that I am a member of the LGBTQ plus community, as some of our colleagues are in this body, that we have heard from our elders recently. And they're very worried that all of the rights and liberties they fought for are potentially under risk. So a proverbial bus might be headed our way, affecting these liberties and these rights. So again, I want to just speak to one aspect of this proposal. The community, the LGBTQ plus community, has been hyper-politicized by outside forces. And I think that's really important and legitimate to note in this moment in our country's history and our state's history. These recent events, and the good Senator Winfield has spoken about that, so I won't elaborate further, but I'd like to say that what we're deciding here, and to remind us that what we're deciding here is not for us to decide this, but for the people to decide this. So will the people be able to decide this? And I think that's a really important thing I wanted to raise. Another aspect of this is that there are many residents all over our state, and every single district in this state and every single legislator serves some of these folks who are not a protected class in our state constitution. I don't want to personalize this, but I'll say I'm one of them for some aspect of my identity, and others are protected. But everybody in this building who serves their community has constituents who are not a protected class in this constitution if they identify as LGBTQ+. So I think, as a reminder, this is just, and I'm really grateful for the ranking senator to remind us this is one of many steps in the process, just almost frankly at the beginning of the process. And that will be something that we work on together. And I would like to just invoke the fact that this is, I think, a demonstration of the push-pull of our society as we journey on this long arc toward justice right now. And it's really emblematic of that. So I just want to call to attention, again, some of the testimony we heard in the public hearing, especially from our seniors, from our veterans who testified. And I want to lift them up because in my mind today, that's where I'm at. I don't want them to lose their liberties and the freedoms that they fought for in multiple ways. And, frankly, there's a theme from that testimony that day that will stay with me. And so there's an incredibly diverse community of constituents that we all share. And I want us to continue this conversation that we're having today. So I urge my colleagues to vote this out of committee. Thank you.
Thank you, Representative Johnson. Is there further comment or question on this resolution? Further question or comment on this resolution? Senator Flexer.
Thank you, Mr. Chair, and thank you for your leadership in this conversation this afternoon. I really want to thank my colleagues, Senator Winfield, Representative Gauthier, and Representative Johnson, and associate myself with their remarks as best I can. We've been having a conversation around a proposal like this in this committee for a number of years, and I think its importance and the necessity of it has never been more clear, as has been laid out in some of the remarks of my colleagues this afternoon. And what we heard, particularly in the public hearing, where hundreds of people came in person, thousands of people submitted testimony online from all corners of our state, from all walks of life, speaking to their fear, frankly, that fundamental rights, civil rights that have been fought for over decades, we're at risk of going backwards. And for many of us, we wake up every day seeing a new headline where a right that was fought for fiercely and is so important for people's freedom to live without fear of segregation or discrimination, where those rights are going backwards. And so that is why this committee has had this conversation for so many years, and why we're having it again this year, is to demonstrate that here in Connecticut, we're going to do everything we can so that civil rights can be protected, so that the people whose work that Representative Johnson and Senator Winfield talked about, people whose work for decades, who's dedicated their lives, frankly, in the 1800s, so that a person like me could sit here, in the 1800s and the 1900s, so a person like Senator Winfield could serve on this committee, and over the course of the last 125 years, so that a person like Representative Johnson could serve in this committee. All of those things in many ways feel like they're under attack for people in our state. And that might not be the universal feeling, but I think the demonstration of public support we saw at this public hearing tells us how important this is. And so I'm grateful to the committee for considering this today. I'm grateful and hopeful that the majority of my colleagues are going to support this, recognizing the critical moment that we're in and the opportunity we have to lead with our Connecticut values here in the state of Connecticut. Thank you, Mr. Chair.
Thank you, Madam Chair. Further comment from the committee? Seeing none, Mr. Chair, or excuse me, Mr. Clerk, would you please call the roll?
This is a roll call vote on Senate Joint Resolution number 35, resolution proposing a state constitutional amendment concerning discrimination on the basis of sex under the Equal Protection Clause. The motion is to JF to the floor. Senator Flexer,
Yes.
Representative Blumenthal,
Yes.
Senator Honig,
Senator Honig votes yes.
Representative Moore-Bello,
Yes.
Representative Osborne,
Yes.
Senator Sampson,
Sampson is no.
Representative Master Francesco,
No.
Representative Branco, Representative Carpino, Representative Fonsello, Representative Gauthier,
Gauthier, yes.
Representative Haddad, Representative Hoxa,
Hawk says no.
Representative Johnson,
Johnson is yes.
Representative Menapace,
Menapace is yes.
Representative Rosario, Representative Santiago,
Santiago, yes.
Representative Shannon,
Shannon votes yes.
Senator Winfield.
Senator Winfield in the affirmative.
Thank you, Mr. Chair.
Thank you, Mr. Clerk. Next up, we have item number 11 on our agenda, House Bill 6846, an act concerning artificial intelligence, deceptive synthetic media, and elections. This is a JF to the floor. I will entertain a motion.
Yes. I mean, so moved.
Second.
Moved by Senator Flexer, seconded by Representative Menapace. This bill would generally prohibit the distribution of certain deceptive synthetic media within the 90-day period preceding an election or primary, and deceptive synthetic media would be, in plain language, described as media purporting to depict someone doing something that did not actually happen, and with the intent to impact an election. It carves out a number of exceptions meant to protect established rights to free speech, including parody, satire, and a high intent requirement in accordance with the First Amendment, depending on the circumstances. And is there further comment from or question from the committee? Representative Master Francesco.
Thank you, Mr. Chairman. This bill, I know we debated it last year. There's one thing that I do agree with AI is, and it is very frustrating, when you look at something online, you really don't know if it's real or if it's AI generated. So I certainly appreciate the intent of this bill, 100%. What I have questions on and concerns on, of when you talk about artificial intelligence, when you talk about, I guess, images, what I'm trying to figure out is, like, let's, for example, on lines 18 of the bill, right? When it talks about what the meaning is of deceptive synthetic media. And it's talking about an image or an audio that was generated in whole or in part through the use of artificial intelligence or other means. So when you talk about other means, what exactly does that mean?
To you, Representative, it would mean any means that was used to alter or create a piece of media in a way that would lead a reasonable viewer to believe that something that had not actually happened had happened and was being depicted in that media. To you.
Thank you, Mr. Chairman. So other means can also be a manipulation of a graphic through, like, Photoshop. It's not necessarily computer. It could be a software change on it. Would that be accurate through you?
Through you, yes, potentially.
Okay. And when you talk about a photo being manipulated based on something that had not happened. So for example, there was a photograph of me. I'm taking a photograph with my family at a park. Are you saying that that had actually happened and I am not supposed to create a photo with an image of a park in the background? Would that be an example? Through you, Mr. Chairman.
To you, Representative, no. This would be deceptive media intended to, again, deceive individuals. It's distributed without the consent of the individual. So if it were an image of you, it would have your consent. And its distribution is intended to injure a candidate or influence the result of an election or primary. And just to be clear, there are also protections in this bill that say if you include a disclaimer, more generally, even if it were deceptive synthetic media, that you could still distribute it so long as there's a relevant disclaimer indicating that it is a piece of media containing such alteration. To you.
Thank you. I guess what I'm trying to figure out too is when you say deceptive, can we be more specific on exactly what we mean by that?
To you, yes. Deceptive synthetic media is defined in the bill, starting at lines 12, as any image, audio, or video of an individual and any representation of such individual's appearance, speech, or conduct that is substantially derived from any such image, audio, or video, which a reasonable person would believe depicts the appearance, speech, or conduct of such individual when such individual did not in fact appear as depicted or engage in such speech or conduct, and b was generated in whole or part through the use of artificial intelligence or other means. To you.
Okay, thank you for that. So the way I'm reading this here is that if I, let's say as a candidate, I have my picture taken to be put out as a flyer, and maybe I have a blemish on my face, maybe my hair is out of place, and I want to have that fixed, right? I have altered that image. Would that be included?
To you, no. As I indicated previously, there is a requirement for such material to be prohibited that the individual who's depicted not have consented to the image. So if you're the candidate, or if you're distributing the image, or if you just consented to someone else distributing the image, then you're in the clear, to you.
Okay, so that clears that. So if I take a picture of, I'm doing a family photo, and somebody in my family, the picture didn't come out that good. Again, they had the same thing. Maybe they had a blemish, something wrong with their hair. The fading was not good. I altered that image. I mean, people do it all the time on Instagram, right? They Photoshop an image to make us look, 20 years younger, which is a great thing. But
None of us would ever do that,
yeah.
Representative Master Francesco. But I could imagine some people out there. Go ahead.
So in all reality, I'm not getting permission from my family, right? I'm taking a photograph of my family. There's something wrong with the photograph of maybe my son, my daughter, or my husband. I'm editing it a little bit. That would fall into this category. Is that correct? To you?
To you, it would have to be intended to injure a candidate or influence the result of an election or primary. And I guess if they did not give you your consent, if they somehow objected and tried to bring a case under this, maybe they could theoretically, but it would have to be material anyhow. I don't think a blemish would count.
Thank you. I'm just using that as an example. But every piece of marketing that is sent out to anybody in a campaign, whether it's an advertisement, a campaign or not, is meant to influence someone. It is meant to change their opinion. Every single piece. So that's really where I have the concern on it. It's very clear in here that it's used to influence the results. I mean, that's why you have a campaign. That's why you're sending out mailers. That's why you're doing audio. That's why you're doing social media. Yes, I admit it. I am trying to influence my base, my audience, to vote for me. That's influence. Would that be correct through you, Mr. Chairman?
I think in general that would be the case. I would just also point out that under existing law, if any of us used somebody's image, at least under most circumstances, without their consent in our media, there would be other causes of action that already exist under common and statutory law that they could use to pursue us. So that's not really a new creation of liability if we're not getting their consent. That's something we already deal with, as long as the big exception to that would be if the photograph were taken in a public forum too.
Thank you. Currently, right now, when you are in a campaign, you're sending out a mailer, there is no photographic release that someone would have to sign in order to put their picture in your ad. Is that correct? To you?
To you, it's not a requirement of law, although I would say to everyone watching, it's good practice. But the release that someone might sign is just a documentation of their agreement that they're willing to be depicted, or that their image, they're giving you consent to use it. So, you should be fine if you get people to agree to appear in your advertisements, hopefully based on an oral representation of their consent. But in general, it is just better practice to get a signed release so you have evidence of that consent later on if they should ever challenge it to you.
Thank you. So I guess I think a lot of us sitting here that have been elected probably have been a target, right, to some type of negative campaign. And maybe they've put our picture in there. I mean, I've had it happen to me, and I'm sure many people on here have had it happen to me, to you as well. But I guess what this is saying, that you cannot use, we will no longer see any pictures of us in a negative way in an advertisement because they're saying here that you would have to give consent. Now, no candidate is going to give their opponent consent to use their photograph in any campaign, right? So I guess what we're doing is we are moving away from that, and it will no longer allow a candidate to put a picture of their opponent in a mailer because you're never going to get their consent, and that's the way I read it here. To you.
To you, Representative, I think we may be talking past each other a little bit. I was talking about existing causes of action for the right of publicity. For instance, in general, if someone takes a private photograph of you and then distributes it without your consent, you could sue them, regardless of any political campaign. There are exceptions to that. The most prominent of them is if the image is in the public domain. And that's how often images of candidates get used in negative advertising. So that would be okay under existing law, which this bill does not affect.
Okay.
And I'll demonstrate why I think the view or the characterization you're making is not accurate of this bill through an example. In my first race for state representative, my opponent took an image of me in the public domain and he made my head very big. I'm not sure why.
I would comment on that, but I won't. Physically or mentally, right?
Well, maybe he could tell the future. I don't know. But anyway, in any event, because this bill would require that a reasonable person think that it's depicting something, or a reasonable person believe that something is happening that did not happen, that image would be perfectly fine. Because I don't think anyone would believe that my physical head was gigantically and disproportionately large for my body, and I will leave figurative statements for another time. But that's just a demonstration of, satire, parody, uses of images or alterations of images to make a point that does not lead a reasonable viewer to believe that something, a real thing that did not happen, happened. All those sorts of alterations of images, all those sorts of images would still be protected. It's just the ones where it's depicting something that literally did not happen that would be covered by this bill.
Okay. Something that did not happen, like obviously in your example, your head got bigger. What if something that did not happen is that the photo was making you look even better than you are? I mean, it right? Maybe someone didn't like the way they looked. Maybe they felt they were a little bit too thin or a little bit too heavy, and they wanted to clean it up and put it out there like that. So maybe they wanted to attack you in a way where they wanted you to just send a message, but they didn't want you to look that bad for some reason. Would that be included in here? Based on what you're saying, right? It didn't happen.
It would depend on the circumstances. And I'll just say for the record, I'm becoming a little uncomfortable with how, with our examples dealing with me in particular. So we may be going down a bad road on this. So, but, in general, it would matter what the significance of the alteration of appearance was. So say, for instance, again, we're not going to use me, but say the appearance of the candidate was altered in a way to show that they had a communicable disease that was very frowned upon in society. I think that alteration of appearance, if a reasonable viewer would see it and say, oh my gosh, the candidate has that disease, that could be prohibited under this law. Now, if it were done in a manner, where pepperoni pizza, pepperonis were put on them or something like that, and it was clearly satire, then it would not be covered. But to some degree, it would depend on the circumstances. Ultimately, the key question is this depicting the person, or is this alteration depicting the person in a manner that a reasonable viewer would say, that thing is real in a physical reality sense? And so those are the sorts of things that will be covered under this bill. To you.
Thank you. Yeah, so it's almost like you're reading someone's mind. You don't really know how they're going to feel if it's reasonable to them to know that. When you actually talked about food for a moment, it literally brought me back a couple of weeks ago. My husband saw an article or an ad in the paper, and it was some really good looking food. And you know how they do that to entice you. He went to eat it and buy it, and it looked nothing like the ad, right? And it tasted terrible. I guess that would be somewhat of an example, right? They altered the ad to make the food look really, really good. You're hungry. I'm like, I'm going to go buy that. And it's nothing like that at all. Again, it's us all the time. So the other part that I have a real concern about here, well, let me just ask you one question going back to to our discussion. Is there a penalty? What is the penalty? If someone, what is it?
Yeah, so any person who violates the provisions of the section shall be subject to a Class C misdemeanor, except that if the violation was committed with the intent to cause violence or bodily harm, or to distribute deceptive synthetic media to an audience, and such audience exceeds 10,000 individuals, that would be Class A misdemeanor, or if such violation were committed less than 5 years after a prior conviction under this section, that person would be guilty of a Class D felony. To you.
Thank you. I'm just going to make a comment on that part. It's interesting how we are willing to fine someone and make it a felony for something like this. But when they commit an election crime, we don't want to fine them for that. I just find that really interesting. The other part in here that concerns me, which I think is to me the craziest thing, when you talk about the message that needs to be on the audio, the video, or the graphic. And I will use the disclaimer that says this communication contains audio that has been manipulated. When it comes to a video, this communication consists video that is manipulated. And I'm saying as an image, this communication contains an image that has been manipulated. This needs to be on there. Or this image has been manipulated. And that font has to be the same, at least the same size as the largest font in the graphic. Is that correct to you, Mr. Chairman?
To you, under this bill as written, yes.
Well, I would think to you, it is, listen, I'm fine with a little piece at the bottom like we do with our campaign. Your paid for language. It's like a minimum of an 8-point or 6-point font, letting people know. But when you have somebody that has a graphic, a picture on there, and it is maybe a 16-point font, it's big, you have to put this language just as big. Like, is that not the craziest thing? I mean, to me, it is, Mr. Chairman. I mean, I wish I did an example or brought in a boards just so you can see how crazy that is. To you, Mr. Chairman, does that also include if someone was doing a billboard? To you?
To you, Representative, yes.
So, oh my goodness. And when you're talking about, so there's a photograph, it's on a billboard. Over the photograph, there's text, right? I'm assuming that's basically how it would work. You're telling me that because the wording that is over that photograph could be on the side of it or right going through it, this wording needs to be at least the exact same size as that. Is that correct to you?
To you, Representative, if the photograph is deceptive synthetic media, yes.
Thank you. And again, I think it's very subjective because many pictures can be altered in many ways. And I know we discussed different ways and different examples, whether it's pros or cons, but they can be manipulated in many different ways. So I have a lot of concerns. Again, I do appreciate the intent of this bill. I do appreciate seeing a little blurb underneath in small text or small print to let me know that this was created with AI. That's fine, but I just think this goes too far And to me, it's very subjective. So I will, for those reasons, Mr. Chairman, I'm not going to be supporting this bill. Thank you.
Thank you, Representative. Senator Sampson.
Thank you very much, Mr. Chairman. Boy, I thought a lot of questions while we were having this previous conversation with my colleague. I think it's interesting, number one, that this bill only focuses on video, audio, or images and not text. I think the title is somewhat misleading because it kind of leads you to believe this bill's really got something to do with artificial intelligence, but it really doesn't, because it's about deceptive synthetic media that's created in any way, shape, or form. And am I correct about that, Mr. Chairman? I mean, it doesn't need to be AI. It could be photoshopped. It could be, I could take a photocopy of an image of someone and alter that and then share it, and that would still fall under the definition of deceptive synthetic media if it met all the other requirements. Is that correct for you?
To you, Senator, obviously, this bill is motivated by artificial intelligence and its ability to readily make such deceptive synthetic media images, but this bill is not limited to them. So you're correct.
Right, I appreciate that. Thank you. That's good. I just want to make sure people understand it's not limited to AI by any real stretch. This is such a delicate situation. I think that people automatically, react to this in a somewhat positive light, and so do I. I mean, my instinct is, yeah, we got to stop this nonsense. But I want to just remind everyone what we're talking about, which is free speech. And in this particular situation, we're not even just talking about free speech. We're talking about political speech, which should be the most unadulterated kind. I was recently involved in a Supreme Court decision where my free political speech was limited by a decision by the State Election Enforcement Commission. And ultimately, it took 10 years of court to go, and a lot of money and a lot of people involved. But in the end, I won my Supreme Court case, and I won unanimously. And it's because at the end of the day, political speech should be protected unless there's a real significant and compelling state interest not to. I'm reading this bill. I'm kind of on board with a lot of things, but I just want to bring up a couple things. Like, for example, I'm less concerned about my opponent trying to make me look bad by altering my image or something like that than I am about them just flat out lying about me. And I filed a complaint in the most recent election because my opponent said numerous things that were patently untrue. He in his campaign literature said that I actually mocked a person in committee based on their race, which never happened, obviously. But he said it. He said that I voted for numerous things I didn't vote for. And he said I was part of a criminal investigation having to do with one of my town RTCs on an issue that I had absolutely, positively nothing to do with. All of those things were done for all the reasons stated in this bill, except that those were all done simply in text. They were not done by image, audio, or video. Is there a consideration here, Mr. Chairman, to get to the real issue, which is not so much the mechanism for the deception, but the deception itself? Through you.
To you, Senator, I would say that this bill considers deceptive synthetic media, especially because those forms are new in terms of their ability to persuade individuals that things that did not happen actually happened, and are able to be shared and are impactful in a different way than traditional speech is. And the common law has provisions to prevent and to punish false statements made with actual malice about anyone, but less than actual malice about some, that damage an individual. And under defamation law and other similar common law torts like false light. And so that is an option that's available to individuals who are hurt by false speech made with the appropriate level of intent. But this bill deals with media, specifically images, audio, and video, because technologically, the ability to make them with an appropriate or with a convincing amount of verisimilitude is relatively new. And also because those forms of media are particularly compelling and could be circulated and damage an individual uniquely in this specific context of a political election in a way that text or speech does not, or traditional speech does not. To you.
I thank you very much for the answer, Mr. Chairman. Although I would suggest that, it can obviously be even more damaging for someone to make a claim, such as I identified actually happened in my most recent campaign, than to simply modify a photograph. I think it could be equally or even more damaging. And as you pointed out, the mechanism for someone who is harmed by that is to make a claim of defamation. Just since I got you here and you have a lawyerly expertise, what are the likelihood, or what are the odds of somebody like me or any other political candidate at the state level being able to sue effectively for defamation because someone, makes such claims about you during a political campaign that are dishonest?
To you, the chances of someone actually doing it are relatively low, because usually the juice is not worth the squeeze for a public official. But the standard for a public official making a defamation claim is relatively high. One has to prove that the statements were not only false, but made with what's called actual malice, which essentially means, in plain language, reckless disregard to the truth. The person who made the statements had to have significant or serious reason to doubt that the statements were true. And so while I accept that the standard is relatively high and that generally it's not worth making a defamation claim as a public official, we kind of generally have to deal with the slings and arrows that we deal with from the public or from opposing candidates. The option does exist, and certainly some public officials have used it. To you.
Thank you, Mr. Chairman. I'll talk to you offline to see if you want to take my case or not. I guess the reason why I asked all these questions was really to compare the option of what we'll call old lying, which is pre-technology lying, is that you've got to go through, a civil case, and you've got to expend funds and attempt to win an argument based on defamation. Whereas what we're creating for new lying in this form of technology, you're just creating a criminal penalty, which will be applied, I think, based in the bill by an accusation from the harmed party and or independently from the Attorney General. If I'm correct about that, you can just correct me if I'm not. Why the disparity? Because it seems to me that what we're setting up in this bill for deceptive synthetic media is the same thing. Effectively, you're lying about someone by saying that they have a big head or what have you, versus just saying that they something else about what they've said or done in their record is harmful to them. Through you.
To you, Senator, one thing I wanted to clarify that I forgot to mention in my previous answer is that under this bill, a public official seeking the protection of this bill would also have to prove that to get any damages or punishment, it would have to be proven that the deceptive synthetic media was made or distributed with actual malice. So it would be the same standard as under our traditional defamation law, which is a First Amendment standard. And I guess I would say, additionally, if someone said that someone had a big head figuratively, that would probably be protected opinion under the First Amendment. But more generally, I think basically the intent of this bill is to deal with new technology that allows individuals to present a false image, media, video that is particularly compelling, particularly easy to spread, could have a particularly deleterious and immediate impact in an election, especially towards the end of an election, in a way that traditional speech generally does not. I accept that there are maybe some circumstances where an old lie could be just as damaging, but as a general matter, these kind of new lies are able to be effective and spread in a way that the old lies traditionally have not. And so that's what I would say is the intent of the bill. To you.
Thank you, Mr. Chairman. I appreciate your answer. I'll just, frankly, I disagree with that. I think the old lie format of, saying that, candidate Smith, murdered a guy or robbed a bank or something like that, I think it could be completely detrimental in the final days or hours of a campaign in the same way. And would there be any interest in I know you're working on this bill, to include other types of deceptive media, like in the form of the old lie format, which is to create a mechanism to actually charge people who are reaching that very high standard you mentioned of acting out of malice. I'm curious. I mean, again, for me, the method of deception is far less concerning to me than the actual deception itself. And if that deception does reach that level and has that much consequence, I think we should treat it the same. I'm just curious if you have an appetite for that, and then I'll leave it at that. That's my final comment and statement on this thing. I'm not going to vote for it, mostly just to flag it, because I do believe we got to fix this issue that was already described by Representative Master Francesco on the disclaimer, and I'm hopeful that gets done. Through you.
To you, Senator, I think as a general matter, the proponents of this bill are open and interested in talking with all comers about how the bill can be improved. That being said, expanding it may cause other people to oppose it or oppose it more. But the conversation, as everyone who's familiar with the workings of this building knows, continues outside of committee on the floor, and we're certainly open to that conversation. To you. Thank you, Senator. Is there further question or comment on this bill? Seeing none, if not, Mr. Clerk, would you please call the roll?
Thank you, Mr. Chair. We are voting on HB 6846, an act concerning artificial intelligence, deceptive synthetic media, and elections. Senator Flexer? Representative Blumenthal?
Yes.
Senator Honig? Representative Morin-Bello?
Yes.
Representative Osborne? Senator Sampson?
Sampson's no.
Representative Mastrofrancesco?
No.
Representative Bronco? Representative Carpino?
Yes.
Representative Foncello?
No.
Representative Gauthier?
Gauthier, yes.
Representative Haddad? Representative Hoekstra?
Hoxa is yes.
Representative Johnson?
Yes.
Representative Menepace?
Representative Menepace votes yes.
Representative Rosario?
Representative Rosario in the affirmative.
Representative Santiago?
Santiago votes yes.
Representative Shannon? Senator Winfield?
Senator Winfield in the affirmative.
Thank you.
Thank you, Mr. Clerk. Next up, we have item number 12, HB 6847, an act concerning an evaluation of the updating of state forms and applications to include a non-binary gender option. This is a JFS to the floor of LCO number 5597. The chair will entertain a motion. Moved by Representative Morin-Bello, seconded by Representative Haddad. This bill does exactly what it says it would. It would require state agencies, and especially the Secretary of the State, to evaluate what revisions or resources are necessary for state forms and applications to include a non-binary gender option. Are there further questions or comment on this bill? Okay. Seeing none, Mr. Clerk, will you please call the roll?
Thank you, Mr. Chair. This is a vote to JF HB 6847, an act concerning an evaluation of the updating of state forms and applications to include a non-binary gender option. Senator Flexer? Representative Blumenthal?
Yes.
Senator Honig? Representative Morin-Bello?
Yes.
Representative Osborne, Senator Sampson,
Sampson is no.
Representative Master Francesco,
No.
Representative Bronco, Representative Carpino,
Carpino votes yes.
Representative Foncello,
No.
Representative Gothier,
Gothier, yes.
Representative Haddad, Representative Hoxa,
Hawk says no.
Representative Johnson, Representative Menapace,
Representative Menapace votes yes.
Representative Rosario,
Yes, only to get it out of committee.
Representative Santiago,
Santiago votes yes.
Representative Shannon, Senator Winfield.
Senator Whitfield, in the affirmative.
Thank you.
Senator Flexer, yes.
Thank you, Senator Flexer.
Thank you. Next is item number 13, House Bill 6848, an act concerning the adoption of municipal conflict of interest provisions. This is a bill we have seen before in this committee, and it is a request of the Office of State Ethics to ensure that municipalities that have not adopted a conflict of interest, that they do so and they submit it to the Office of State Ethics. Is there a motion to JF House Bill 6848? Motion has been made by Representative Morin Bello, seconded by Representative Menapace. Is there discussion? Representative Master Francesco.
Thank you, Madam Chair. Yeah, this bill has come before us in the past. While I do appreciate the intent of this bill, I always stay true to my word and make sure our towns have local control and their own autonomy. Although I would highly recommend that they certainly would be a good idea for them to have a policy for a conflict of interest. What I don't like is necessarily making it a law and making it a mandate on a town. So for that reason, Madam Chair, I'll be voting no today. Thank you.
Thank you, Representative. Is there any further discussion? Seeing none, Mr. Clerk, will you please call the roll?
Thank you, Madam Chair. We are voting on HB 6848 to JF an act concerning the adoption of municipal conflict of interest provisions. Senator Flexer,
Senator Flexer votes yes.
Representative Blumenthal, Senator Honig, Representative Morin Bello,
Yes.
Representative Osborne, Senator Sampson,
Sampson is no.
Representative Master Francesco,
No.
Representative Bronco, Representative Carpino,
Yes.
Representative Foncello,
No.
Representative Gothier,
Gothier, yes.
Representative Haddad, Representative Hoxa,
Hawk says no.
Representative Johnson,
Johnson is yes.
Representative Menapace,
Menapace is yes.
Representative Rosario,
Rosario in the affirmative.
Representative Santiago,
Santiago, yes.
Representative Shannon, Senator Winfield. Thank you, Madam Chair.
Thank you. Next, we will move on to item number 14, the most controversial item of the day, House Bill 6849, an act concerning the Legislative Commissioner's recommendations for minor and technical revisions to the Government Administration and Elections statutes. Is there a motion? Motion has been made by Representative Morin Bello, seconded by Representative Haddad. Is there discussion? Seeing none, Mr. Clerk, will you please call the roll on item number 414, House Bill 6849, and I can keep reading the title if you're trying to switch out. That would be 6849, an act concerning the Legislative Commissioner's recommendations for minor and technical revisions to the Government Administration and Elections statutes. Mr. Clerk.
This is a roll call vote on House Bill 6849, an act concerning the Legislative Commissioner's recommendations for minor and technical revisions to the Government Administration and Election statutes. This bill is to be JF to the floor. Senator Flexer,
Yes.
Representative Blumenthal, Senator Honig, Representative Morambella,
Yes.
Representative Osborne, Senator Sampson,
Sampson is yes.
Representative Master Francesco,
Yes.
Representative Bronco,
Yes.
Representative Carpino,
Yes.
Representative Fonsello,
Yes.
Representative Gauthier,
Gothier, yes.
Representative Haddad, Representative Hoxa, Representative Johnson,
Yes.
Representative Menapace,
Menapace votes yes.
Representative Rosario,
Rosario in the affirmative.
Representative Santiago,
Santiago, yes.
Representative Shannon, Representative Senator Winfield,
Senator Winfield in the affirmative.
And Blumenthal is a yes.
thank you. Representative Hoxa, did you-
Yes.
Thank you. Thank you, Mr. Chair or Madam Chair.
Thank you, Mr. Clerk. Next, item number 15, House Bill 6850, an act concerning revisions to the Freedom of Information Act concerning the non-disclosure of addresses for certain public agency employees. The chair would entertain a motion to JF this bill.
So moved.
Motion has been made by Representative Blumenthal, seconded by Representative Morambello. Is there discussion? Yes, Representative Master Francesco.
Thank you, Madam Chair. So this bill has come before us since I can remember that I've been on this committee, which has been quite a while. And this particular one, it did not start out actually including the employees of for every single employee. Can I clarify that, Madam Chair, that this includes every state employee to you?
Yes, thank you, Representative. This proposal is like proposals we've seen in the past that limits the disclosure of home addresses for public agency employees, all home addresses for all public agency employees. Excuse me, unless their home residence is of concern to their employment. For example, in many towns where you have a town manager, you have to reside in the town that you are the town manager of. That would be an example of an exception. But other than that, public agency employee home addresses would not be available for disclosure for FOI purposes.
God, thank you for that clarification. So we do know that a lot of information can be done online and you can get this information, but as we've said every year, employees for the state of Connecticut work for the taxpayer. The taxpayers are paying their salaries. They certainly have a right to know certain information about that employee, in my opinion. And again, it's a matter of we keep expanding the freedom of information of what areas should be exempt from freedom of information. And this one pretty much opens the door wide for pretty much every person in the state of Connecticut that works for the state, that is an employee, except with the exceptions of the ones that you said. So I will be a no on this today. And I'll tell you, we're going down a slippery slope with our, we're trying to, and it almost seems like you're trying to hide information. We don't want to be transparent. There's nothing wrong with being transparent. I mean, when you take a job working for the state of Connecticut, you know this going into it. You already know. For us as legislators, our addresses are not hidden. Everybody knows where we live. Mayor, we had our state our state senator Harding had a bomb threat at his house, and yet he's not down here telling us to hide his address. So we deal with it all the time. You work for the state. Those are the requirements when you work for the state, and something we just have to deal with. So I'll be a no today, but thank you, Madam Chair.
Thank you, Representative. And if you don't mind, I completely respect the example that you gave, and I don't presume to know the feelings of Senator Harding and his family this week. However, I would point out that I would hate to see something like that happen at Senator Harding's staff's address, just because their home address under current law would be accessible to an FOI request just because they happen to be a public employee that works in the Senate Republicans. So that's my counterpoint to your argument, but I appreciate the sentiments you've expressed. Is there any further discussion? Seeing none? Mr. Clerk, will you please call the roll?
This is a roll call vote on House Bill 6850, an act concerning revisions to the Freedom of Information Act concerning the non-disclosure of the addresses of certain public agency employees. The motion is to JF to the floor. Senator Flexer,
Senator Flexer votes yes.
Representative Blumenthal,
Yes.
Senator Honig, Representative Moore-Bello,
Yes.
Representative Osborne, Senator Sampson,
Sampson is no.
Representative Master Francesco,
No.
Representative Bronco,
No.
Representative Carpino,
No.
Representative Fonsello,
No.
Representative Gauthier,
Gauthier, yes.
Representative Haddad, Representative Hoxa,
No.
Representative Johnson,
Johnson is yes.
Representative Menapace,
Menapace is yes.
Representative Rosario,
Rosario in the affirmative.
Representative Santiago,
Santiago, yes.
Representative Shannon,
Rep. Shannon votes yes.
Senator Winfield. Thank you, Madam Chair.
Thank you, Mr. Clerk. Next up, we have item number 16, House Joint Resolution 47, a resolution proposing a state constitutional amendment to allow individuals who have attained the age of 16 to apply for admission as electors and to be so admitted upon attaining the age of 18. This is a JF to the floor. I will entertain a motion.
Second.
Moved by Senator Flexer, seconded by Representative Menapace. Is there further comment from the committee? Seeing none, Mr. Clerk, will you please call the roll?
This is a roll call vote on House Joint Resolution number 47, resolution proposing a state constitutional amendment to allow individuals who have attained the age of 16 to apply for admission as electors and to be so admitted upon attaining the age of 18. The motion is to JF to the floor. Senator Flexer? Yes. Representative Blumenthal?
Yes.
Senator Honig? Representative Moore-Bello?
Yes.
Representative Osborne? Senator Sampson?
Sampson is no.
Representative Master Francesco?
No.
Representative Bronco? Representative Carpino?
No.
Representative Fonsello?
No.
Representative Gauthier?
Gauthier, yes.
Representative Haddad? Representative Hoxa?
No.
Representative Johnson?
Yes.
Representative Menapace?
Yes.
Representative Rosario?
Yes.
Representative Santiago?
Santiago, yes.
Representative Shannon?
Rep. Shannon votes yes.
Senator Winfield? Thank you, Mr. Chair.
Thank you, Mr. Clerk. Next up, we have item number 17 on our agenda, House Joint Resolution 48, resolution ratifying the proposed amendment to the Constitution of the United States permitting Congress to regulate child labor. This is a JF to the floor. I will entertain a motion.
Second.
Moved by Senator Flexer, seconded by Representative Menapace. This resolution does pretty much exactly what it says it would do. In 1924, Congress proposed an amendment to the U.S. Constitution to allow it to regulate child labor, sent it to the states. The amendment is still outstanding and unratified, and this would signal Connecticut's ratification of that amendment. Is there comment from the committee? Senator Sampson.
Thank you, Mr. Chairman. Yeah, I mean, obviously you read the title of this, and obviously we want to make sure that we protect children from, harmful, potentially dangerous employment. The thing about this is that in order to support this ratification, that means that you believe that it's the federal government that should be regulating child labor. And I just disagree. I believe the state of Connecticut has its own compelling interest to regulate that. And I would prefer that we make our laws and we simply do not rely on the federal government to determine what those laws are. And I'll be a no today. Thank you.
Thank you, Senator. Further comment or question from the committee? Seeing none, Mr. Clerk, will you please call the roll?
This is a roll call vote on House Joint Resolution number 48, resolution ratifying the proposed amendment to the Constitution of the United States permitting Congress to regulate child labor. The motion is the JF to the floor. Senator Flexer. Representative Blumenthal.
Yes.
Senator Honig. Representative Morambello.
Yes.
Representative Osborne. Senator Sampson.
Sampson is no.
Representative Master Francesco.
No.
Representative Bronco. Representative Carpino.
Yes.
Representative Fonsello.
No.
Representative Gauthier.
Gothier, yes.
Representative Haddad. Representative Hoxa.
No.
Representative Johnson.
Yes.
Representative Menapace.
Yes.
Representative Rosario.
Affirmative.
Representative Santiago.
Santiago, yes.
Representative Shannon.
Rep. Shannon votes yes.
Senator Winfield. Thank you, Mr. Chair.
Thank you, Mr. Clerk. That leads us to the final item on our agenda, House Joint Resolution 49, resolution memorializing Congress to rescind previous applications of the General Assembly calling for an Article 5 convention to propose amendments to the Constitution of the United States. This is the JF to the floor. I will entertain a motion.
So moved.
Moved by Representative Menapace, seconded by Representative Haddad. This is kind of an interesting one. In, I believe, the 1940s, we sent 2 requests for a constitutional convention to Congress. One, I believe, was to make a world government, and the other was for an amendment to allow the taxation of other states' income or income of individuals in other states. This would rescind those applications for a constitutional convention and prevent them from being a mechanism by which an Article 5 convention would be exercised. Is there further comment from the committee? Seeing none, Mr. Clerk, will you please call the roll?
This is a roll call vote for House Joint Resolution number 49, resolution memorializing Congress to rescind previous applications of the General Assembly calling for an Article 5 convention to propose amendments to the Constitution of the United States. The motion is to JF it to the floor. Senator Flexer. Representative Blumenthal.
Yes.
Senator Honig. Representative Morambello.
Yes.
Representative Osborne. Senator Sampson.
Sampson is yes.
Representative Master Francesco.
Yes.
Representative Bronco. Representative Carpino.
Yes.
Representative Fonsello.
Yes.
Representative Gauthier.
Gothier, yes.
Representative Haddad. Representative Hoxa.
Yes.
Representative Johnson.
Yes.
Representative Menapace.
Yes.
Representative Rosario.
In the affirmative.
Representative Santiago.
Yes.
Representative Shannon.
Rep. Shannon votes yes.
Senator Winfield.
Senator Winfield, in the affirmative.
Thank you, Mr. Chair.
Thank you, Mr. Clerk. That concludes the committee's business for today. I will, however, make an adjustment to the time on which votes are open, or until which votes are open, with apologies to the clerk. The votes will be held open until 5 p.m. Thank you, and we recess until 5 p.m.
Right. What do you need? What do you need? I will get to you in 1 minute, Representative Carpino. How are you, Representative Carpino?
Good, thank you. I'd like to cast my votes
Oh.
for 1 through 10.
Sorry, hold on. I didn't have my volume up.
I'd like to cast my votes from 1 to 10.
Okay, so I have, do you have the agenda with you?
I do.
Okay, thank you. I have, I need a vote for SB 1226.
No.
SB 1227.
No.
Uh, 1228.
Yes.
1229.
Yes.
1230.
No.
Where's the folder back here?
1231.
Yes.
1232.
Yes.
However much you want.
1233.
Yes.
1234.
I just kind of zone out.
Yes.
SJ 35.
No.
Yes. Just double checking. All right, you should be all set. Thank you so much.
Thank you.
How are you, Representative Rosario?
Yourself?
I'm okay. I'm good. Excited. I need your vote for 1226.
In the affirmative?
1227.
In the affirmative?
1228.
I was just
In the affirmative?
until we had everything else done.
1229.
In the affirmative?
1230.
In the affirmative?
1231.
In the affirmative?
1232.
In the affirmative?
1233.
In the affirmative?
1234.
The affirmative?
Let's give this to you.
Thank you, sir.
Well done.
SJ 35.
In the affirmative? Officer Staples.
That's good. Make sure you.
I should be all set from you. Thank you so much.
You have a good afternoon.
You too. How are you, Senator Winfield?
I am well, and I will not surprise you. All of my going to be in the same direction, but let's go.
So 1226.
In affirmative.
Um, 6848.
In the affirmative.
6850.
In the affirmative.
8HJ47.
In the affirmative.
HJ48.
In the affirmative.
Thank you so much.
You have a great weekend.
You too.
Murray!
How's it going, Representative Shannon?
What is up? What did I only miss two?
I believe so, but let me just double check.
Cool.
Um,
I should have just stayed in the room anyway. The meeting that I ran to, they actually canceled on me, so.
It's not like
They
you
giving
would
you excuses for why you didn't come.
Yeah.
You man, everyone's asking, "Where's MJ Shannon? Where's MJ Shannon?"
All right, so for 6846, how would you like to vote?
6846, I am a yes.
All right. 6847,
I am also a yes.
6848,
Yes.
6849,
Yes.
that should be everything. Thank you so much.
Thank you so much, Murray.
Have a good weekend.
You too.
So this one, how's it going, Representative Osborne? Oh, you're on mute.
Good, how are you?
Good.
Good. So what'd I miss?
Let me see, and I'll let you know. Okay, so do you have the agenda?
I do have it in here somewhere. Let me see. Let's put you down for a second. Hold on. I did.
Okay, so I'm missing your vote on 6846.
Okay, I'm a yes on that.
Okay. 6847.
Oh, I'm sorry, that's a yes.
Oh, that's okay. 6848,
Yes,
6849,
that's two votes. Okay, yes,
6850,
yes,
HJ 47,
yes.
um, House Joint 48. Sorry, I didn't catch that. That was a yes, I think.
Uh, I I was just not aware we were okay. Let me take a look at that because 1 second. We come back to that one. Let's go to the other one.
Sure. The last one was House Joint 49.
Let me get back to you on those two. I didn't have those on my radar as we're actually voting on them.
All right. It sounds good. The votes are open till 5 p.m. So as long as you get it before me till then, I should be okay.
Okay.
Thank you.
Hi, I'm back. So
Back
that's,
again.
that's a yes to resolutions 48 and 49.
All right, that sounds perfect. Thank you so much.
Thanks so very much. Bye.
Have a good weekend. Bye.
You too. Bye.
How are you, Senator Honig?
Good, thanks. How are you, Murray?
Hold on 1 second. I just gotta put my stuff down.
No worries. How's being the clerk treating you?
Good. I'm excited. So
Awesome.
I get the vote tallies open. Oh,
Everything made it through?
I still have to tally everything up. Um, but I will post the votes after that.
What's that?
I said I just have to tally everything up, but I will post everything after then.
Mm-hmm.
All right, so would be I need your vote on 12:30. How would you? Do you have the agenda, or did you need me to?
I don't have the agenda.
All right, so I'll.
Let me see if I can bring it up here. How did Matt and May vote on that?
They voted yes.
Okay, so I'm a yes.
Okay. 12:31. That's act concerning state contracts with nonprofit human service providers. They both voted yes.
Okay, I'm a yes.
And then 12:32, an act implementing the recommendations of risk limiting audit working groups. They both voted yes.
I'm a yes.
Okay. 12:33, an act exempting the name and address of an individual reporting an allegation involving bigotry or bias. They both voted yes for that.
I'm a yes.
All right. 12:34, an act making certain terms, electronic book, digital audiobook license agreements. They both voted yes on that one.
I'm a yes.
Okay. HB 6846, it's the artificial intelligence one. He voted yes on that one.
I'm a yes.
Okay. And then 6847, act concerning evaluation, state forms for non-binary option. They both voted yes.
I'm a yes.
Okay. HB 6848, act concerning the adoption of municipal conflicts of interest provisions. They both voted yes.
I'm a yes.
Okay. 6849, legislative commissioners' recommendations for the revisions. They voted yes for that.
I'm a yes.
All right. 6850, revisions, Freedom of Information Act, the address of certain public agency employees. They both voted yes.
I'm a yes.
Okay. HJ 47, that's the constitutional amendment to allow individuals who are 16 to apply for electors. They both voted yes.
Yes.
Okay. HJ 48, the resolution for ratifying the amendment for regulating child labor. He voted yes on that.
I'm a yes.
Okay. And then last one, HJ 49. That's the memorialization Congress to rescind the applications for Article 5. So he voted yes on that.
Yes.
All right. That should be everything. Thank you so much.
All right. Thank you, Murray. Have a great weekend.
You too.
All right. Bye-bye.
Hello, Senator Flexer.
Hi, Mr. Clerk. How are you?
I'm good. How are you?
I'm good.
All right, so I just need, I believe there's 3 outstanding votes. It's, go to them. It should be 68, 46, and then H.J. 48, and then 49.
Okay, Senator Flexer votes yes.
Okay, vote yes for all 3?
All 3.
All right, sounds perfect. Thank you so much.
Thank you very much. Have a nice weekend. Thanks for
You
everything.
too.
Bye-bye.
Thank you. Bye.